All right,
All
all
right,
set.
thank you. Thank
Problem.
you. Um, Good evening, everyone. Today is July 27th, 2026, and this is the meeting of the Northborough Planning Board. First on the agenda is the reopening of the public hearing for 409 Green Street. This is the application of Tower Company and Verizon for 409 Green Street for the application for wireless communications facility, special permit, site plan approval for erection of a 130-foot tall monopole with 5-foot antenna accommodating 9 panels, antennas, 6 remote radio head units, and associated equipment within a 70 by 70-foot fence compound. Um, Thank you all for rejoining us on July 27th. When we left off last time, I mentioned that Carter, you wanted to say something?
Yeah, I'll have to leave for the conflict of interest. Do you have any guess on how long you'll be talking about this?
No idea. Sometimes we think an hour, sometimes an hour and a
Yeah.
half.
Okay, if someone can just text me if I'm not on when you're done.
Okay, Lori, do you mind doing that when we're done? Okay.
No
All right,
problem, Carter. I'll let you know when it's good to go.
Perfect.
thanks. Okay, so when we left off, I wanted to speak to town council, which I did. And Robin Stein is with KP Law and she's here with us tonight. Thank you. And after talking to her, I decided to reopen the hearing and leave it open. That way it's more flexible during deliberations and discussion. Last time I got stuck and I had questions I wanted to ask, but I couldn't because I had closed the hearing. So tonight, since we reopened it, we can ask additional questions of the applicant. We can take input from the public. And so again, I'm going to leave the hearing open until the end of the hearing. When speaking with Attorney Stein, what I wanted to do was verify the process that we needed to do when we deliberated and voted. So when deliberating a special permit site plan, we have town criteria that we go through. So with this, I guess what I was supposed to do was go through the town criteria first for special permit site plan, and then go on to the federal criteria. So after talking to her, that's what we're going to do tonight. We can also start by going through the waivers that we never really had a chance to discuss. And I don't plan on taking motions at first. Maybe we can discuss and take some straw polls. But I think we should have a good discussion as a board before I try to make any motions. So as part of the process with our board, Lori sometimes sends out conditions that we can use as a baseline. And those can be discussed also, should the application be approved, because I'm not speaking for the board, whether it's going to be approved or not approved, and I'm not telling anyone what to do. But that's the process we usually go through. And this application has a lot of legs to it, so I had to think of a way of how we were going to go forward. Before I start, I wanted to ask the applicant a question because I did ask the applicant a question at the last hearing before I closed it. And I think it was mentioned that someone would be here tonight that could answer and make decisions. I was wondering, is there someone here tonight that could make decisions on conditions that we brought forward?
Yes.
Oh, okay. And who's would that be? Is that you, Attorney Fenton, or?
Sure. I mean, I'd be happy to introduce our team that's here tonight. So my name is Attorney Michael Fenton. I'm a partner at Schatz, Schwartz and Fenton, 1441 Main Street in Springfield. I will say, Madam Chair, and just for the public's information, I'm joining you remotely. I'm at a family vacation. So for continuity purposes, I wanted to be here for the start of this. But my colleagues, Attorney Ellen Fryman and Attorney Brett Smith from my firm are also here. So if it does turn out that the hearing goes a little bit later than I'm able to stay, Attorney Fryman's prepared to take over. In addition, we're joined tonight by Carrie Fazzolari, and Carrie is internal counsel to Tower Co. who can speak to any business decisions proposed relative to the conditions that were circulated.
Okay, thank you. So it's you, Brett Smith, and Alan are from Verizon?
From Schatz, Schwartz and Fenton, representing both TowerCo and Verizon Wireless, and we're counsel, and Carrie is internal counsel for TowerCo.
Okay, all right, thank you. I guess starting off, one thing I wanted to bring up is since this is the question that I asked last time, but I didn't have a chance to get any answer because there wasn't someone here that could answer for it. But since this location is in an agritourism section, like this is a main economic development engine that attracts tourists from all over the state. Tugas Farm in that area. It's a farmland area on a scenic road. It leads to many conservation parcels within our town. And our bylaws and master plan state that we should protect the natural, historic, scenic, and aesthetic qualities in the town. And from what we heard from all the residential letters that, you know, the aesthetics are very important. So the question I had at the last meeting was, should this application be approved? Again, I'm not saying how the board is going to vote because I can't talk for them. But if it was approved, would the applicant be agreeable to a silo and barn configuration that's consistent with the one that was built by TowerCo in East Lyme, Connecticut? If it was a silo and a barn, we wouldn't need the abrevieties around it, and the equipment would be in the barn. So then you wouldn't hear when the generator was backing up, and it would help with the aesthetics, including any lighting, sounds, and with the silo, it'd include all the 3 locators. And there's a lot of equipment on that pole. It looks very industrial. It would go a long way, in my opinion, of covering the aesthetic concerns that are throughout our bylaw, whether it's the, you know, the wireless section 710-040, whether it's a site plan, whether it's a special permit, they all point to the importance of the aesthetics in our town. So I had asked that question the other time, so I was hoping I could ask again tonight.
Sure. We are not willing to proceed with a faux silo design, as you've just outlined, Madam Chair. I would like to respond in a few ways, and then if Carrie or anybody else would like to elaborate, I'd allow them to. It's my recollection at the last meeting, after several meetings and several hours of discussion near the end, you asked a much more generalized question than the one that you just posed. You asked if we would consider camouflaging the tower in some way. And I don't believe I said that someone wasn't there with authority to make a decision. Carrie and other stakeholders from TowerCo were there. I just said that it was unfair to ask that question at that point in time because it would take an extensive amount of review and zoning documentation to demonstrate what that would look like, what that would cost, etc. We were surprised to receive a request from the town to reopen the hearing after it had been closed by yourself and the other members of the board at the last meeting. And based on our conversations with Ms. Connors, we understood that the reason for this request was that you wanted to discuss exactly that point, more specifics about alternate camouflaging or stealthing for the design. It was on Friday of last week, just one business day ago, that we received the written proposed conditions to approval from Ms. Connors, which included the faux silo design. And I just wanted to make sure that that was a part of the record, that was really how that request transpired. Nevertheless, after consulting with TowerCo, that proposal is both cost prohibitive and we feel inappropriate in this particular context, and we are not in a position to offer that as a stealthing solution for this site.
Is there anyone from TowerCo that can explain, you know, the difference in price between the stealth tower and the silo and why it's cost prohibitive?
Carrie, can you speak to that?
Well, I can't get into the exact costs because I honestly don't know them. I just know that they are triple what we would normally pay, and we just can't do it. It's just an unreasonable amount of money.
And we would also, Madam Chair, just reiterate the prior testimony that we've given you from our experts, including the certified appraiser and the photo simulation expert who provided what is our professional testimony of very minimal visual intrusion in the town for this proposed tower. In other words, there's a very narrow window through which you would be able to see this tower across town.
This is a super important area of our town. Like, we have an Apple Fest. It's our biggest, everything has to do with apples and Tugas Farm and Davidian Farm. And
We've
I did
submitted
see,
we just want to reiterate, we did submit a letter in support from Tugas Farm for this proposal.
right.
And the
I don't know if
Davidians,
they've
the
read the
Davidians
whole
are also in
application.
favor of this proposal.
Yep, I'm not trying to argue with you about it, but East Lyme, they did do it, Tower Code did do it. So I was wondering if you had the costs between, how much did it cost to do this silo and barn down in East Lyme, and you were able to do it there, and I'm just curious why we can't do it here, because it really would help to go a long way if you read our bylaws, and everything is about the aesthetics and the rural scenery and the farmland, and a tower that has all these antennas on it that looks very industrial just looks out of character there. And so we were hoping that Verizon and Tower Co would do the same thing in Northborough that they chose to do in Lyme, Connecticut.
Well, with respect, Madam Chair, I do feel that it's very unfair to show that photo that you just shared your screen with, and to ask us at the 11th hour here to provide answers for a site that many of the consultants, myself personally, have no experience with working on the call. As you know, and the other members of the public and the board know, we have been working on this site with the town for many months. We have many public hearings. If there was a request for that type of information, it could have been made in advance of this meeting, and we may have been in a position to provide it to you. But asking it in the manner in which you just did is not conducive to being able to provide the actual facts and circumstances for purposes of comparison. I will reiterate again that we are willing to paint the tower to a color of the board's choosing, and we're willing to also provide additional camouflaging with appropriate landscaping plantings.
All right. And I don't want to argue with you back and forth, but I did mention the silo at the last meeting. And it was a silo, it wasn't just camouflaging. And I'm not trying to argue with you. And I just, in the best interest of our town, felt it was fair to ask, because they have done it in other towns. And if you can't do this, I mean, what could you do to make it more palatable for our town, like, other than just paint? Like, it's a wide open field. It's wide open. It's not highly, camouflaged at this point. And it's very tall. Is there anything that your company could do to camouflage this?
Well, again, it would, as we provided in prior testimony, it would not be the tallest tower in town. Wouldn't be close to one of the taller towers in the region. It is not tall by comparison to other permitted towers. This board has approved other monopoles on this subject site. As you are aware, those towers are not camouflaged. We have offered to paint the tower, and we've offered to landscape the tower, and we've provided professional expert evidence to support the de minimis impact that this would have on the view sheds in town, and professional evidence that it would not impact property values. So it's our testimony tonight that we are prepared to provide the painting of the tower and the additional landscaping. Unless Carrie has anything to add, that's as far as the applicant is willing to go.
Carrie, do you have any other input to add?
No, I don't, Michael. summed it up nicely.
Okay, well, it is a surprise. I mean, we did reopen this due to the fact that I wanted to reopen it because after I talked to town council, she said it was best to keep it open to discuss different things. And she also gave us other advice, but I'll go into that later. But I guess, I don't know if I can ask Attorney Stein, is there anything more we can ask for camouflaging or, I guess I'm surprised, but I don't know if board members have anything else to add.
I mean, can you think of any other things that might help other than the painting that have been mentioned that might help sort of bring the aesthetics a little bit more into? Have you done anything like that with other towers that might not be as complicated as the silo, but might actually be more palatable? I'm not sure if that's the right word or not. Aesthetically.
I know in 2015, the monopole that was approved was a monopine. And that's up to how like board members feel of the looks. Like it is close to some pine trees, so it could match in, or maybe it will look silly depending on the height. But I do see, Bill, you have your hand up.
Oh, you're
Oh,
muted,
you're
Bill.
muted.
Sorry. If I can share my screen really
Sure.
quick. I happened to be driving through Westboro the other day and I happened to notice this. So, I appreciate what TowerCo is trying to do because if you think about it, this is the other option. This is in the center of Westboro. That's 4 towers, probably about at least 50 feet high, maybe even up to our limit of 70, all congregated together. No painting, no disguise, no nothing.
Hmm.
That would be perfectly legal. I mean, except for maybe some of the setbacks. So we need to be careful here what we're asking and make sure that, we're not going to put ourselves in even a worse situation by, trying to push this in a direction. So that's all I wanted to show. Thank you.
As part of our bylaws, there's only one WCF per mile. So hopefully, they shouldn't be able to do that. I think that's why there's a condition that the current 72-foot tower on 351 Ball Street would have to come down before this new one would be proposed. But I think our bylaws state you can only have one per mile, and that's where they have the circles on the picture. But I see Anthony, you have Mr. Fenton, you want to say something?
Yeah, I just wanted to state that the other 13 conditions that were presented to us on Friday, we are prepared to accept those other conditions. It is just the condition regarding the camouflaging that we're not able to accept for the reasons stated.
I just have a quick question for Lori. Didn't all those conditions go out to them before Friday, I thought? Like a long time ago?
They went out on Friday. So I sent the draft decision to you folks. And then within a few minutes, I sent the draft conditions to Mike Fenton and Brett.
But I think with your review letter at the very beginning, a lot of those conditions were in your original review letter. In
That is correct. Yeah. And also I took a number of the conditions from Mike Lawton's review letter as well.
Mhm.
So those had been forwarded weeks in advance.
So really the only new conditions that went out on Friday was the silo and the trees.
I
And
wouldn't
maybe it
go
was-
that far. I mean, there may have been some additional conditions that were, I'd really have to think about it, that
Mhm.
were new in these draft decision.
Okay, I think I remember the majority of them were in your review letter, but again, I would have to go back and review that too. But I remember a letter saying that the attorneys were amenable to the conditions that you put in your review letter.
Yeah, definitely one of the new conditions had to do with the street trees at the
Mhm.
80-foot interval. So that was something that I did not bring up in prior review letters.
Mhm. Okay. And Mr. Fenton or Attorney Fenton, you mentioned that Lori had reached out to you about some kind of camouflage like a month ago.
I'm sorry, I was just trying to go back in my files and look at the review letters. We certainly didn't see the conditions proposed in this way, and certainly nothing about the conditions that we're taking issue with. I'm not saying that we were surprised at the other items, because many of them were vetted with this board and with the town planner extensively over the last several months, including the condition to take down the other tower. We weren't surprised at those items. We can accept them, but we were surprised to get the silo proposed condition.
So that wasn't brought up. Like, I thought you said like it was brought up a month ago. Camouflaging, including silo or monopine or.
The planner explained when she called, Ms. Connors called to request that we appear at this reopened public hearing, and explain that the purpose of this meeting would be to discuss additional camouflaging. So that's why we're here. We were prepared to discuss that and hear what you all wanted to review. We did not know or expect that there was going to be a proposal for a faux silo until Friday afternoon.
So she never brought up a silo.
I did mention a few different options. I mentioned the flagpole, which Attorney Fenton said would not work because the antennas could not fit inside. And then I mentioned the tree, and I mentioned the silo.
That is
So
correct. That is correct.
I was under the impression that those two options were something that you would consider, but the flagpole you would not consider.
We considered all of them, and we would consider any proposal from the board. There were different reasons for the elimination of the flagpole versus the silo. The reasons for the elimination of the silo are primarily cost and substantial cost related to that camouflaging. The reasons for the elimination of the flagpole were related to the inability to accommodate all of the necessary equipment in a pole of that size at the proposed height. But none of these items were proposed formally by the board. I appreciate the work that Ms. Connors has done, and she's been a terrific conduit between the applicant, the public, and the planning board, and she's been incredibly professional throughout. So I want to thank Lori for all of that. But Ms. Connors can't speak for the board. The board chose to close the public hearing, and we can't accept proposals for camouflaging except through this public hearing process that we're in right now. And through that, we've evaluated the proposed silo and faux barn, and we provided testimony for why that is not something that we're prepared to proceed with.
If Towerco has done it before, is it something you could bring forward? You know, we also opened the public hearing in like April with
Mhm.
no testimony until May 19th, I think. Or was it March, with no testimony until May 19th because of the 2 months to do the
Balloon test.
balloon test. And then we waited 2 months, and unknowingly we could have probably froze the shot clock so it didn't keep running. And now we're down to the wire, and you know, we were asking you for the difference or how you can try to make this more palatable for the neighbors in the town and the businesses that are up there. And I feel like, if anything, I'd like to ask to extend the shot clock. So maybe you could come back to us with the cost differences, or maybe another way to make it more palatable to the neighbors, because it is going to look like the picture that Bill just showed, the metal pole with the antennas on top. It may not be 4 of them, but it's going to have 4 co-locations on it possibly. And it will just look very industrial up in this residential neighborhood. And this is the first tower that's going in a residential neighborhood. So as a board, you know, I feel you have to really think hard on how to make this more palatable to neighborhoods. I mean, this is the first one. The other ones that you mentioned before, the tallest one is near the police station. It's on municipal property and it's on Route 20. And the other one too is Kearney Park. That's a monopine. It's within the trees. You can't even see it from the road, and it's on a main road. But it's only like 100 or 100. I think your RF reports say 100 feet or 120 feet. And then up in the senior center, another municipal property, that's under the 135 feet, and that's also within the trees, and you can barely see it. This is, and there was one more, on Church Street.
On Church Street.
And that was done so long ago, it predated our zoning, and they pushed it way back in the woods up along 290. So you can't even see it from Church Street. I didn't even know it was there till we started talking about this. So I'm just asking if the applicants can actually just think about the residents that we're here to represent too. We're here to represent, you know, all residents, and think of a way where this can be more palatable in a residential neighborhood. It's in the middle of a field. And if we put some 12-foot trees along the road, it would help, but it's not going to help enough. Like, I didn't know I couldn't show that picture of the silo. Our company has done these silos and barns before, so I had brought it up as a picture just to show, you know, how this would blend with our community in our residential neighborhood, in our farming community that has people come from all over the state to go up there. And now we're going to have an industrial, you know, antenna pole. So that's all I'm trying to do. You know, you're representing your client, but we're trying to represent our town. And this is the first one there. And it really means a lot to everybody, including the board.
Mm-hmm.
Well, thank you. And we definitely want to work with the town, and we've tried within the bounds of what we can do reasonably on behalf of the client while meeting the wireless objectives and being financially reasonable. And I can tell you, having a lot of experience doing citing for proposals across all of Massachusetts on behalf of TowerCo and other carriers and other tower companies, the client has spent quite a bit more in resources to get answers to the board and due diligence to the board as it's requested to address many, many issues that have been brought up over the months here. And so we want to reiterate that commitment to working with the town and to being a good neighbor. But in terms of the specific request for additional camouflaging, we just can't honor it in the way that it's being requested. And we've, I think, honored virtually every other request for additional documentation or conditions that the board and the residents have requested. I understand, and I too, Madam Chair, do not want to get into a particular back and forth, but I do just want to point out that while every site is different, and you feel and have characterized this site as being materially different from other sites in town, there are 2 other sites that are sited in residentially zoned parcels. You may not consider them to be residential in nature, but the property at 119 Coburn Street is in Residence C, and the property on Church Street, 348, is in residential A and B. Those towers are 150 feet each, which is materially higher than our proposed site. And the one located on Church Street is approximately 80 feet from the nearest lot line and 200 nearest house. So these are in residential areas in town. And some of the other towers you mentioned, the tower at 211 Main Street, it's 175 feet tall. So this proposed tower would be materially shorter and have substantially less visual effect than those other towers based on their zoning and their height and proximity to other uses.
The one on Church Street was approved before we had any zoning for cell towers. And they had to get a variance to put the house there. Like the cell tower was there before the house. So the people moving in knew what they were, they were getting. It didn't come in after the fact. And that's just the only thing I want to say. And the other one too, at the senior center on Colburn Street, it was zoned industrial when that cell tower went in. So it had a higher height limit, but I don't know when it changed to residential, maybe in 2009 when we did our zoning changes. But I went back and read the decision and I think it said it was industrial at the time.
I
So
think it's also, I'm sorry, Amy.
Oh, it's okay.
Attorney Fenton does bring up a good point that these are existing in our town, but this does have a specific, it has a specific qualifier in that it is a scenic road. And I think that changes the elements that to some degree as to why this might be more aesthetically uncomfortable or not in keeping with what we have as already designated a scenic road. That to me is a main differentiation that I would like to see considered.
Anthony, I saw you had your hand up before. Do you have anything that you wanted to add?
I was just curious. I know that we talked about the monopine. I was just curious if the applicant would consider that, or not saying it's appropriate or not, but just wondering if it is something you guys would consider.
Carrie, can you answer that?
Yeah, we had talked about it. We would consider a monopine, but we'd have to run the costs on that as well, just given the amount of money we've already spent on the site.
And one other question is, I'm just curious really, is, so have you painted other towers in other places?
We've painted them where the antennas are brown and the pole itself is brown, and it just kind of blends in. It doesn't look as industrial. It looks more like an odd tree-like look, but it's that brown. It's called sturdy brown.
Okay, thank you.
You're welcome.
And I've had similar experiences with other tower companies. We had recall one tower being conditioned on painting the tower sky blue, but that ultimately wasn't, the board in the end didn't like that choice because the sky isn't always blue. So we've found the most common color choices are brown or green. And I'm just a lawyer. I'm not the visual expert, but it would seem to me that in this particular setting, that brown, to Carrie's point, would be the most appropriate.
My opinion, if this were to be approved, I would rather see a tree in a way, but I'd rather hear from, residents, like maybe approval on camouflaging with, we talk about it after the fact, if it can't be talked about tonight. And, I have such a hard time that the Connecticut Siting Board wouldn't have asked more questions than we did as a local planning board in the town of Northborough. I guess I keep going back to the East Lyme because Connecticut has a siting board that all cell towers have to go through, and I'm not sure how tough they are, but I would think they're a lot tougher than little old Northborough. And maybe because they are so tough, they got their silo and barn in. And I have a hard time, I believe you, but I have a hard time believing, even though I do believe you, that you spent more on this application, because I felt like we asked questions, but I didn't feel like we asked that many questions. Like some towns could send applicants out to go talk to like 10 more sites and other things. So I feel like we've been pretty fair as a board. I felt that we were very fair with the extra 2 months for the balloon test, but I thought it was important that we saw how high it was going to be. And
Mhm.
I think after seeing how high it was, that asking for some camouflage just isn't too much. And that's where I'm grappling with this whole thing. And
Can you
I mean,
make
we
it
could,
look like the Eiffel Tower?
we can go forward and go through all the, through all the, through all the decision, but I'm afraid, I'm not sure what's gonna happen if there's not enough
Mm.
aesthetics, because that's like the one thing that's in all of our bylaws, whether it's site plan, special permit, or wireless and master plan, is that the applicant thinks about the aesthetics, and I feel like painting it brown just isn't enough. So, Anthony, I see your hands up.
To the chair, can you comment a bit about dates and deadlines and when things need to be absolute?
I think the shot clock is, and Attorney Benton and Lori, if you can back me up, I think it's August 2nd or August 4th.
It's
Is the end
August
of the shot?
2nd, Sunday.
August 2nd, which is Sunday. We could put in a request to extend it, but sounds like they're not going to be willing to do that because they don't want to look in further the cost differences.
Oh,
But
can
I'm not
Can
sure
I-
if they'd be open to coming back in a
I
week or
just,
two.
yeah, I just want to be clear. We did look into the cost differences, and we've taken the position that we are not willing to spend that unreasonable of an amount. So
for the
I just
silo?
want that to be clear on the silo and the barn.
Okay.
If you looked into it, you don't have any of the numbers of the difference between the pole and the silo?
It's an enormous difference.
That just means different things to different people. I asked ChatGTP, and I know they're not, it's ChatGTP, so you get different answers all the time. But
So
they
it's
did.
just Towerco is running a business, and Towerco rents out space to the carriers. The financial obligation of putting up a silo and a barn would not put Towerco in the position of conducting their business. It's a loss. So that's where we're coming from on it. And we feel that we've met the requirements of your code, and that we're offering to put up more trees along the road, to put up more than what we would for a typical tower in your area. And by offering to paint the tower and by putting in extra landscaping and all of that, we believe we've made that offering already.
And we will also agree to the removal of the existing tower on the site, the co-location of the existing tenant on our tower, and the free occupancy for the town of Northborough for its public safety equipment.
Okay.
Can I just ask you a quick question on that? The other site is, Lori, can you clarify if there's one tower there or two? Because in some of the information, it says there's actually two towers.
So there are two towers. It's my understanding that one of the towers is for farm business. And then the other tower has the public safety equipment for the town of Boylston.
Okay, for some reason I thought they were both on the same tower. Would there have been just?
They're on the same property,
Right,
but they're
no, I
two
know that.
separate towers.
Okay, because I thought the original approval was for something on an existing tower. Never mind, that's fine.
Yeah, the town didn't have to approve the other tower because agricultural uses are exempt.
Got it. Thank you.
Anthony?
Yeah, so a quick question. So I know you agreed to the trees and painting, and then we talked briefly about the monopine, and I kind of don't think we've got a solid answer whether that was something you consider, or because it kind of seems like we don't have a lot of time to put that in a condition if we don't know what the answer is.
Yeah, the monopine is something that we would consider.
Okay.
They did that in 2015. It was going to be a monopole, and they just changed the word from monopole to monopine in the decision. So if that's the way the board wanted to go, you could do that,
I guess I'd like to hear from the residents on that.
right?
Mm-hmm.
Okay.
So can I just make a couple of comments about the shot clock, because I felt completely stressed by that. And I just want to express that we had 150 days from the time the application came in, which was March 5th, to August 2nd, which is 150 days. And of those 150 days, 75 of them, we did not get to see or speak or interact with the applicant in a public format. So I felt completely crunched when all of this started to fall into place. Sometime, I would say in June, because we saw it for the first time or discussed it for the first time on May 19th. And so I also feel I have a few more questions that I would just like to get a little more information on before I feel comfortable making what I think is that decision.
So I also want to, I just was corrected by my teammate about the monopine, and it was also something that we considered, and because it's cost prohibitive, we're not open to a monopine either.
I feel like you're tying our hands. I mean, when we did it back in 2015, it was last minute. There was no qualms about doing a monopine. I would like to at least hear the difference in costs. Like, and now you've said okay, now you're saying no. What is the price difference? Like, I feel like as a town, I feel like Verizon is not considering the town at all. And I would like to, can we extend the shot clock to at least just get the price differences? So we can consider that?
But it's not going to change anything. If we give you the costs or we don't give you the costs, we're still not open to doing the silo or the monopine. So it really doesn't make a difference whether we give you the costs or not. Because we've already spent so much money. Yeah, that's where we are. I know it's not the decision you want to hear, but it's a decision. I don't even like saying it, but happen to be the spokesperson tonight.
Attorney Stein, what happens if we go through with an application and we approve it, but we approve it with the conditions of a monopine? What would happen there, or can you give some advice?
I mean, I can't speak for the applicant, but I mean, an applicant can always approve can always appeal a condition. I think, if they don't like, if you approve it and there's something that the applicant doesn't like or think they can do, they can appeal the condition in the decision.
Okay, now does that go to court? Does it go to ZBA? Like, what is the process? If,
Goes to court.
say, okay,
It goes to court.
And if I can, Madam Chair, just,
But again, I can't speak for the applicant, so.
okay, I was just wondered, like, because I didn't have the chance to ask at the last meeting process and what happens, what are next steps? Should it be denied or should it be approved yet with a condition? Because sometimes we do close the hearing and then you make conditions that aren't conditions that are worked out in advance with the applicant. So I just didn't know the process of what happens. And Attorney Fenton, you had something you wanted to add?
yeah, it was just to return to the point about the timing. So I don't mean to interrupt and sidetrack you if you want to continue.
No, that's fine. I think I said what I was going to say.
Okay, so the only point that I wanted to make is that we have tried earnestly and in good faith to work with the town and with this board. And it's true that we did submit our application in March, and there were some weather reasons why the balloon float had to be redone. And ultimately, we spent some extra money and brought a crane out to the site. So there were delays, understandable delays for those reasons. But it's not like we weren't proceeding in earnest due diligence during that time. We first received the comments from the town's consultant on our application on April 5th. So there was back and forth taking place even before the first open public hearing that took place for this site. It was the only point I wanted to make.
Right, right, but we did not see that until maybe 2 days before May 19th, what the back and forth was.
We have
been
made
a lot
ourselves
of-
available. We've made ourselves available to every public meeting that the board has asked. The board decided at the last hearing that it wanted to close the hearing because it felt it had enough information at that point in time. Based on the testimony that you're hearing from us tonight, we do not think it's a reasonable request to extend the shot clock, and we are not willing to do it.
Well, you weren't available in true form on the April 7th meeting. You had a person who came, Brett Smith, who I think was on tonight, as sort of an administrative role, but there was really no conduct of discussion at that meeting. And it was your choice to push it to May 19th.
We can't control the board schedule. The board would have needed to vote to push it to May 19th. That was a decision that the board made.
On April 7th. And we could have made it on May 5th, but it was asked to be on May 19th, not by us.
I would just say that in my personal professional experience, I've done hundreds of these sites across the Commonwealth, and this is one of the longest hearing schedules that I've experienced in my professional career in the last 15 years.
Because have you had 2-month delays in getting information?
Yes, for weather, yes.
Then maybe they
In
didn't-
terms of the
legislatures-
extending the shot clock, what are you thinking about? Like just extending it enough to get a written decision out, or is it extending it for 2 months? Because if it's 2 months, then no.
No, not in my mind. Amy, do
Millie, you
have a-
mentioned you had some questions. Do you have them tonight or is that the reason?
Yeah, I actually would love to see, I mean, the applicant has stated that they've been working on this for almost 10 years, and I would like to see maybe more actual documentation, such as emails that support some of these efforts that were made to seek either alternative or feasible options. We did get information that is, says that there were some phone calls made or some conversations, but we really have no evidence of any documentation of what was.
You're asking for evidence that we explored the financial feasibility of these other options.
I wouldn't say the financial feasibility, more just the actual project or plan feasibility of the, summarizing what's been done over 10 years. And we really, I don't feel like I got that there was that much evidence for doing what I would say is if you've done these things multiple times or hundreds of them, then you might expect that you have to show that you've done some due diligence, and that maybe emails would be a good way to represent that, hey, we communicated with these people, not just we tried to reach them, or we, went to the site and talked to somebody and they said no, or just, I just feel that's a little bit on the shallow side of what I would like to see. Says this was thoroughly investigated as a feasible option versus some other options. And if there's
I'm
no
super
emails that show any of this communication, I am gonna have, it's just a challenge to sort of, yeah, that's all.
I think
I'm
what,
very
what I-
confused. I'm very confused by this request because we have been doing this since May. Let's just say May. And we've gone back and forth with your expert. We've answered every question you've asked. And I'm not feeling, I don't know, I don't even know what you're asking us to provide.
I guess what I'm asking for is, one of the things that has to be considered is how much effort went into looking into other places, which was asked and has been asked multiple times. And we got I think it was a 1-page synopsis of what that looked like. And I'm feeling that it just doesn't really, it doesn't really show what probably is some of the effort that was made. How do we find the, I would think that this would be something that would typically be requested or asked for.
We, thank you, Member Milton. We have provided several versions of constraints maps for your decision-making process. We made several revisions to those constraints maps based on requests by yourself and other members of the board, as well as your consultant. We also, as you indicated, provided testimony from our site acquisition specialist, who was involved in identifying the appropriate location and entering into the leasing arrangements with the Davidian family for this subject site. And we also provided written support testimony from one of the properties that we approached in Tugas Farm. We understood that the purpose of this hearing today was to talk about the camouflaging. So, I mean, if you had asked us for emails or documentation of that kind previously, in addition to the other requests that we honored, that is certainly something that we would have been willing to go back and do. We're not in a position, obviously, to answer that for you here tonight.
Right.
No, we don't think it's reasonable to extend the shot clock to allow those questions to be answered because of the due diligence that we made in good faith. I did get an email, I believe it was this morning, from Ms. Connors indicating that this particular type of question could come up tonight. And unfortunately, there's just not enough time to get that kind of information together for you. You may recall in my prior testimony, I told you that this search ring was opened in 2016. So would be an effort that would take more than a couple of hours to go back and provide the documentation and the evidence that you're looking for.
Right.
But you do have our sworn testimony. You do have our sworn testimony, and you do have the testimony of our site acquisition professional, and you do have the various versions of the site constraints map, which were prepared and submitted in the record.
Right. I'm not actually questioning the choice of this property or the selection. I actually was not under the understanding that this was just to be talking about camouflaging, so I'm not sure if I'm the only board member that doesn't understand that. I actually thought this was open for more questions and public comment. So I am sorry if I either am misunderstanding the purpose of this meeting, or if you know, if I'm out of line asking questions. But I definitely am not looking for the answers to your constraints map. I was just looking for I would say evidence, support, or that more documentation that supports what you've already claimed. We have a 1-page note that says you know, starting in 2022, that says, oh, by the way, we've been working on this since 2016. Great. I don't need to see all that. I would just love to have seen some of the effort in communication that was made to the either Tugas family or that was made to Boylston. It's all through either phone calls or just walk-in. So I don't know if they were accurate or not. How do I know? I'm not
I'd
saying
like
you're
to-
not telling the truth. I'm just saying there's no evidence that supports what you're saying.
I'd like to respond to that in a few ways. First, don't mean to suggest that any question or request for information is inappropriate. You are a dual member of the planning board in the town of Northborough. You are within your rights and your obligations on behalf of the town to ask these questions. It's perfectly appropriate. All I'm saying is that we conducted several public hearings with this board, and at the end of every other public hearing, there was a list of questions that we had, things that you'd like us to come back to you with. Please update the constraints map. Please contact the town of Boylston. Please respond to all of these various issues. And at the last meeting, the hearing was closed. And the stated intention was that you would reconvene with the intention of making a decision at your next meeting. So when you reached out to us, when the town reached out to us about reopening the public hearing, we were told that one of the primary reason was to discuss camouflaging. We didn't have an opportunity to talk to the board about any other issues. So we came tonight expecting that to be the primary focus. It doesn't mean you can't ask other questions. It just means that we're not prepared to answer questions that you're asking for the first time tonight. And in all the hearings that we've had, you have not asked us for that documentation. Had you asked us for it, we would have provided it.
Had I thought that I might be looking for it, I would have asked for it. But as I've, obviously reviewed much more of the materials over the last 2 months, these questions will come up as I look at things.
And
I saw you provided some. I didn't see any real evidence of it, but it was all, I don't need to really, get too far into this, but I'm just asking for, some justification of why we should kind of overlook some of our bylaws to accommodate and provide what you would like. Think we're being asked to do a lot as a board. We have bylaws in the town that basically say these are the things that the residents want, and we're being asked for good reason to justify why we shouldn't pay attention to that, why we should dismiss the bylaws.
We're certainly not asking you to dismiss the bylaws. We would, I believe, you can correct me if I'm wrong, but I believe that every single request for information that has been made by this board has been honored throughout this hearing process, with the exception of the questions that we're hearing for the first time tonight.
I agree.
So
I agree.
That's our testimony, and we're just not in a position to answer questions that we're hearing from the first time tonight that we don't have information in front of us about.
Okay, fair enough.
I just want to make it clear for the board members, because they weren't part of this. I was the chair. I went to talk to Attorney Stein, and it was about the last meeting. I closed the meeting, then I had questions, and then I wasn't sure about process. So we reached out to her, and the town, and she recommended that we open it up. So if there are other questions that we could, ask them, because I closed it and then I couldn't ask questions, not even about process, because I was going in the wrong direction. So we thought the best way to do it was, versus deliberating without being able to ask anything, would be to open it up. Because another question I had for her was on significant gap. I don't know if you guys remember, but at the last meeting, when we were trying to vote, a big discussion was on significant gap and what constitutes a significant gap. And when I was going through my process of deliberating, I was thinking, the significant gap was just to Northborough. But she did confirm that we have to look at Northborough and Boylston. So that changed the way I looked at things. So if I had to look at Boylston and Northborough and the significant gap was there, then how could we work with the applicant to make it more appealing to the neighbors? I wasn't trying to do anything, and I knew that, I can't talk to the other board members, so they don't know why it was reopened. They just got the same public hearing that everybody else did.
Mhm.
But since I had to look at Northborough and Boylston, and then it looked more like there was a significant gap, how can we mitigate that at all? It was, maybe you should ask for camouflaging. So that's why Lori threw it out there, probably as one thing that we're opening it for, because that was something that could be discussed now that there is a significant gap that includes two towns. And so we're trying to work together, work in the best interest of Verizon and the best interest of Northborough. And I just thought we could get all on the same page. And it was thrown out there, if you're gonna bring it up, maybe, we had to wait for it to go back out for a butter notices and everything, but maybe let the applicant know that you were gonna ask that. So you were prepared tonight to know that we were gonna ask for some sort of, at least I was, because I was the one who got to ask the questions. Nobody else here on the board got to ask the questions to the attorney. So nobody else knew why, and I mean, the neighbors don't even know why. Nobody knew why this was opening again tonight. And it was opening up again tonight because I'm not a lawyer, and I did close the hearing, and then I had questions that I couldn't ask. So we reopened it so I could ask some of the questions, and so we could work together with the applicant, because she did say in a lot of cell tower decisions, the applicants work with the town to go through the conditions, so you want to leave it open, which is why I stated at the beginning, I was planning on leaving it open until the end of the decision. So there was nothing, we weren't trying to bait and switch or trying to pull a fast one. It was all just trying to work with the applicant in the best interest of the town. I know they have the best interest of their client, but we have the best interest of our town. And so those are the reasons why, for any board member out here too, and any applicant and any abutter. The whole reason to open it up was to find out the process and to ask about the significant gap, which I did, but I didn't do it in the meeting because I had the opportunity as chair to ask, town council, but nobody else here knows that. And that's when I decided, maybe I'll ask about some camouflage. And I was actually pretty excited when it came back that Verizon was willing to do some camouflage. So it's actually very disappointing and shocking to come tonight and hear the opposite. So, I mean, that's all I'm trying to be is open, and I know people are asking you questions because they have no idea why this is being reopened. They just figured that it's continuing. So I don't know if anybody else has any questions for me or Attorney Fenton or Attorney Stein from Town Council. Probably not.
Let me see, I might.
I'm just really disappointed that that there's such a hard stance on no camouflage, where I see it from all over, even in our own town, like you said, when we asked on Carney Park, can you do some camouflage? It took them a second to say, sure, we'll do a monopine. It wasn't, you know, it wasn't a big deal to them. So
Bill has his hand up.
Bill?
So I just want to make something clear, Madam Chair, and I'm not trying to be disagreeable here, but from what I've heard, they are willing to do some hiding of the pole by painting it, right? So I think saying none would be an incorrect statement. I would say saying some would be a more correct statement. And I want to be really clear on what's going to be put in the minutes going forward.
Okay, I didn't mean that. I guess for like the past few weeks, I was kind of excited that the board would see the silo and barn that was going to happen up on Ball Street, because it matches with the farmland and Tuga's farm and even Davidian's other barns and silos. So I was pretty excited, which is why I had it ready to show. So I was shocked that everything had changed.
Well, if I could just, if I may, Madam Chair, respond to that. I don't think there's any reasonable basis to be shocked. We never agreed to any camouflaging of that type. And it's our testimony tonight why.
Yeah, I believe that there was no agreement, but it was up for consideration. That was it.
We agreed to consider
Yep.
additional concealment elements, and we're here tonight to tell you that we did. And the reason why we're proposing the concealment elements that we're proposing.
Mm-hmm.
Okay. Does any board members have anything else to state? I mean, I am going to open up for public comment because this is a public hearing again.
I guess one of the things that does keep coming up is that I think it's come up twice, is that the cost of the monopine, and that basically the amount of money that's already been spent trying to get this project off the ground kind of precludes the aesthetic changes of monopine / barn / or silo. Would a monopine have been considered if it hadn't taken so long? If it had been 2 months shorter, perhaps the delay?
Very hypothetical question. I'm not comfortable answering, but I can tell you that the cost associated with this site isn't just the due diligence and the reports and the time that's been spent. Although, while I don't have a figure in front of me, I imagine that figure is in the hundreds of thousands of dollars. We also are agreeing to, at great expense to TowerCo, remove the existing towers and co-locate the Boylston equipment on our tower and give free rent to the town of Northborough. Those are all things that cost money and get built into the pro forma that builds out and considers the economic feasibility of this site.
Mm-hmm. But that's not really related to why we're here. That is like buying a contaminated site and saying, well, I got to pay for the cleanup, so therefore the cost should be less. It's not the way that goes. Just point. It's an existing condition.
It's an existing condition on an abutting property that we don't own or control, but are agreeing to, at our expense, remove for the town and provide free co-location to those carriers, to those towns on our pole.
Mm-hmm.
I'm just wondering, our bylaws only allow one WCF per mile. So if it wasn't agreed to take it down, then, I mean, would this one be denied because our bylaws state only one WCF per mile?
That was actually one of my questions.
I mean, it's a moot point because we're agreeing to take it down. So
you have to take it down. So the cost of it is part of the project.
I would be careful, again, I would be careful. I don't know that that's a WCF because it's not a wireless carrier. It's actually being used by the town for their police. So it may not fall under a WCF.
Yeah, we don't, to Mr. Pierce's point, we don't take any legal position regarding the characterization of the pole because we don't have to get to that question right now because we've agreed to take it down.
Okay.
But I will point out to the board, based on the questions from Ms. Milton and the point raised by Mr. Pierce, you'll notice in our application materials, we do not request a waiver for being within 1 mile of another WCF.
And that was my question, is why?
Because we did not take the position that that tower is a WCF.
Okay, interesting. I thought we approved it in 2023 and it was, but I could be wrong.
It's not the
I have the
subject. It's not the subject of this hearing. We've agreed to take the pole
I
down.
agree. I agree. I'm with
I
you
have the
on that.
definition. A
Mhm.
wireless communications facility shall mean a facility used for the purpose of commercial or public wireless communications uses such as cellular telephone services, enhanced mobile radio services, microwave, personal wireless services, paging, and the like. Such facilities shall include towers, antennas, antenna support structures, panels, communication buildings, communication structures, and accessory structures in their entirety or as separate components. So it does sound like it would be a WCF, and I do think our decision in 2023 said it is a WCF.
That's what I thought.
Well, it also sounds like that definition would include a small cell utility pole installation as a WCF, which I think clearly the intent would be that it not, based on our prior hearings. But in any event, we've agreed to take this tower down, so it's not a matter in dispute before the board.
Do any board members have any more comments or questions?
I think I'm good.
Okay, well, I can come back to you again. I'm going to open up for public comment. Does anyone in the public have any comments?
See any?
I know there's so many people online. So raise your hand if you can, and if you can't raise your hand, just speak out.
You
Oh,
have
I see Sharon.
Mhm.
Can you please state your name and address?
Yep, Sharon Berube, 359 Green Street. I just have a couple comments. The two sites that Mr. Fenton mentioned earlier, Church Street and Coburn, just want to note those were not in scenic areas. So that's number one. Number two, I also had questions about other sites. I don't need details, emails or anything, but I would like to know how many other sites were seriously considered for this.
Okay, Attorney Fenton, do you mind speaking to that?
Yes, just that we've answered that question several times in the past based on our constraints map and our site acquisition professional testimony. I don't have the materials in front of me to answer it tonight, but we've answered that question several times.
So under 10, do you think? Any idea?
Under 10 sites that we have evaluated? No, it would be
Correct.
many more, many more than 10 sites that we evaluated.
Okay. Because I ran some things today on properties on Green Street in Boylston, 3+ acres, came up with a total of 41. And there's some in particular, 12.09, 12.23, 19.93. I mean, and some of them at not the same elevation, but probably pretty close. And I think since you were considering the Haven, that elevation is definitely different than up here on the hill. I also ran it for Mile Hill Road in Boylston. I ran 3+ acres, 31 properties came up. And actually, the town of Boylston has a combination of 95.55 acres. Not sure if any of that's conservation, but I was just trying to get an idea on really why this particular site in the middle of an open field. Same thing, ran Green Street in Northborough, came up with 56 properties, 3.3+ acres. And there's one site in particular very close to this, 9.43 acres and 12.3 owned by the same homeowner. That particular site would allow it to be tucked in the woods very nicely, which we probably wouldn't be able to see or barely see it. I mean, I can go on and on. Smith Road, Northborough, same idea, that had 18 properties. So I just wanted to bring that up. I know you have mentioned it before. I didn't remember the exact number that you had looked into. Another, a question that I have, I know it's been mentioned that you have a right to increase the height of the pole in the future. And I'm wondering, A, if that's true, and B, if so, by how much?
Through you, Madam Chair.
Sure.
Okay, so I believe what you're referring to, ma'am, is the what's known as the Spectrum Act, Section 6409.
Yeah.
It does allow for additional installations on an approved tower, and it does substantially constrain the review that a town can conduct based on those types of installations. So in other words, for example, if a carrier wanted to co-locate on our tower and the tower was permitted and constructed, we could be compelled by the town to submit to a hearing of this kind and a special permit, but the federal law would prohibit the board from rejecting the application, much in the same way that the federal law prohibits this board from considering health effects or from prohibiting wireless coverage, which our testimony is we need to be able to provide that.
Okay, so with that being said, is there also a number on how much you can increase the height of the pole by?
There is, and we submitted written testimony to the board answering that question, I think, 2 months ago.
And what was that answer?
I do not have it in front of me tonight, ma'am.
Okay.
Attorney Stein, could you speak to that? Isn't it 20 feet?
I think it's generally 20 feet. I don't know what the applicant submitted to you previously. My involvement's been more recent. So I would, defer to the applicant to refresh the board's memory about their own submissions.
Okay.
If it's material to the board, I can take a brief recess and go look for the documentation and get back to you with it. Is that something you'd like me to do?
I see Mr. Lawton just popped up, so he might have the answer.
Believe the answer is 10% of the tower's height or 20 feet, whichever is greater.
What did you say, 10% or what?
20 feet.
10% of the tower's height or 20 feet, whichever is greater.
Okay.
Is the standard.
So we could be upwards of 150 feet basically at some point. Is that correct?
Could be.
Any tower in the United States of America under that act can be increased by that height without the town having the ability to deny. In the same way,
I understand that. I understand that. But what I'm saying is this tower could eventually end up over 150 feet, correct?
Yes.
Okay. All right. That was all I just wanted clarification on that. The next and last point that I
do just want to say, Madam Chair, if I may, that the tower is designed to accommodate the additional carriers that is required by the town's bylaw. So there is no intent to request a height extension. So while it is legally and technically feasible that could happen, that is not our intention. And the tower is designed to be able to accommodate the co-locators below the top antenna array for Verizon Wireless.
Some towns write a condition that you wouldn't go up another 20 feet. Would you be willing to do that?
We would accept that. Whether or not that is legally enforceable under federal law, I don't know. I've never been asked that question, but we have no intention of increasing the height of the tower above 35 feet.
135.
135 feet.
35 would be perfect. We're okay with that.
We wouldn't have been here.
35
Yeah,
feet isn't even the height of the barn, but yeah, 135
Right.
feet.
I wasn't inferring that you did have intention. I just wanted to know like a worst case scenario down the road. That's all.
We would accept a condition that the tower, I'll gotta confirm with Carrie, but Carrie, we would accept a condition that the tower not be higher than 35 feet, notwithstanding the federal protections. Can we agree to that?
Yep, we can agree to that.
And then my last question / comment is, there's been a lot of talk of
Madam Chair,
Sure.
sorry, before you move on, this is Robin Stein from KP Law. Can I just ask for a clarification on that one?
Sure.
On the condition, would that be okay?
Sure.
Okay, what,
Go ahead.
it's through you, but, I want to understand if the applicant's willing to have the condition not just say the max height's 135, but essentially that the 130 plus the 5-foot antenna already includes their as of right additional 20 feet.
I think we would be willing to do that. Is that right, Carrie?
Yes, that is right.
Thank you. Thank you. Sorry to interrupt. Appreciate it.
right, but Mr. Fenton just referred to the Spectrum Act, I believe, which would override any agreement, I would think. I'm no attorney.
Well, no,
but-
that's so again, if someone tested it in court, we would see what a judge said. But my question was whether or not they'd be willing to have the condition essentially read that what's approved is 115 feet and they're automatically exercising their 20 feet in the total. This tower is going to be the 130 plus the 5-foot antenna for 135. So their right to go up 20
Yes.
feet is included from the get-go. That's what I'm saying. To
We
have
would
it worded that way, and I think that's the best way to word it for it to be defensible under the Spectrum Act. That's what I'm talking about.
Agreed, and we would agree to that condition.
All right, in my last comment, question, whatever, there's been a lot of talk about gap coverage. Well, when you literally go on the Verizon website, it shows no gap. It shows 5G, it shows 4G, and 4G Lite, it says mature, highly reliable network blanketing 99% of populated areas in the US. So literally right from the Verizon coverage map, it does not show a gap in Berlin, Boylston, in this area. So can you, I don't know, we got the gap information from you, but yet Verizon's own website contradicts that.
So I can probably speak to that since as an objective reviewer, it's my position to not necessarily support or deny Verizon's plots. Though the plots that you're referring to that are on Verizon's marketing website are sales plots, and boards have found, and in fact judges have found, that those plots are not representative of the actual coverage. Those are marketing pieces, and they should be treated as such.
And we
So that's-
also answered that question in our supplemental submission dated May 12th on page 4 of our 169-page submission that day. So that question has come up and been answered.
So that's interesting, Mr. Lawton, because that's like the opposite of what I've been reading, but that's neither here nor there. And, I guess you would think, I get it that it's marketing, but I would think that it would have to be fairly accurate too. But, okay, thank you. That's all I had.
I can put a little more color on that. I've worked in the industry for a long time. All the carriers have similar representations on their websites. And when technical people go out and measure signal coverage in the field, the marketing pieces don't hold up. They're very much overstated.
Okay, thank you. I see Larry and Kristen Blanchard. Can you please state your name and your address?
Yes, Larry Blanchard, 366 Green Street. I just have a very quick question. As we talk about the towers, my sense is that there are actually two towers that exist on the adjacent site right now. We're talking about taking one tower down, but there's going to be another tower that exists. So are we talking about ultimately two towers, or are we talking about one tower?
I think I'm answering for them, but they can follow up. I think they're taking down the one that has the municipal antennas on it. But Lori stated that there's a second tower that might have farming equipment on it, but we may have to follow up with the building department to see what's on that other tower. But from what, Lori, correct me if I'm wrong, I think you stated that the other tower might have farming antennas on it that predate and that a lot of farming equipment is allowed by right, or?
Yeah, that's my understanding, is that the other tower supports the farm operation and agriculture. This particular use, agriculture, is exempt from most zoning.
So Lori, do you know whether the first responder tower for Boylston is the metal tower and the agricultural tower is the phone pole?
It's the one that's behind the building, and
Because,
there's a fenced-in enclosure.
but I think
That's the one that has the Boylston equipment.
but isn't that the one I thought, my understanding, I could be wrong, but my understanding is the farm pole that has been there forever was refitted with the first responder antennas, and that's the one that has the generator. I could be wrong, but I guess I'd want clarity on which tower is coming down.
I'm pulling it up on the GIS, if you can just bear with me a minute.
Sure, I appreciate your patience and assistance.
If I may, Madam Chair,
Sure.
we I don't believe that testimony from Mr. Blanchard's correct. Right? We'll let Lori pull up her screen here, but I think the metal pole is the one that has the Boylston equipment on it with the generator.
So, can you see my little hand?
Yes,
Uh-huh.
I can't see what's in the picture, but I can see the little hand moving around.
So this is the tower that I'm referring to with the equipment, the compound.
Yeah, is that the metal pole or the wooden pole?
That is a metal, I'm sorry, it's a wooden pole. So let me see if I can.
Okay,
get
and
a
now we can
street
see
view.
that, we can see that wooden pole. I believe it has 4 antennas at the top. That was, I was told, and I don't know, it was, not necessarily from a credible source, but those antennas were retrofitted for the first responder equipment. I just wanted clarity, is that correct or not correct? Is that the pole we're talking about taking
This
down?
is the tower that I'm referring to.
As coming down?
This is the one that will come down.
Okay, and the shorter metal one will stay? And is the shorter metal one also a telecommunications in some form tower? And does that fit into the mileage separation requirement?
It is my understanding that the other tower is for farm equipment.
Can we confirm that?
That is correct.
That the short one is for farm equipment? The metal one?
The one to the right, I'm not sure which one is shorter. I think the one to the right that Lori is highlighting, that's the one that's for the farm equipment.
Okay,
The whip antenna that you see on the pole to the left in the screen, that has the Boylston equipment.
okay. All right. And so to be clear, so the telephone pole would come down and the other metal pole would stay because it's for farm equipment. Is that a correct understanding?
Correct.
Okay, perfect. Thank you.
So can I ask a quick question on that one? That one's at 75 feet, right? The one for the Boylston,
I believe it's 73 feet and
72?
change,
72.
73.
So would that be located at a 72-foot height on relocated at 72 feet?
Madam Chair, if I may, through you.
Sure.
Just communicating with my client here, and in the interest of working with the town and the neighbors and the board, if the board does approve this tower and conditions it on the removal of both towers, we would accept that condition. We'll need to work with the landlord to find out what farm equipment's on there and get it over on our pole, but we recognize the concern that's being raised about that additional structure, and we would accept a condition to remove both poles. We are trying to work with you here.
Thank you.
But that would be conditional, I'm assuming, on, because that's a private tower, on the land, the owner actually allowing you to remove it, correct?
Carrie, can you help me out here with an assist? I think what we're saying is that we understand the board's position with respect to this, and if you condition our ability to put up our proposed monopole on the removal of those other two existing poles, that we would accept that condition. We would take responsibility for working with the landlord to allow for those poles to be taken down and the equipment co-located on our proposed structure. Do I have that right, Carrie?
Yep, perfect.
Okay, thank you.
Let me just be even more specific, Mr. Pierce, to help you. If for some reason we could not get the permission from the owner of that pole to take it down, then we would accept and concede that your decision would not allow us to put our pole up. Now, that does not mean that the exact timing of it is going to be precise. There may be a little bit of an overlap for, a short period of time after the tower is up when that equipment has to come down and be relocated. And we would accept a reasonable condition for what that period of time would be, but it would not be in advance of the erection of our proposed monopole.
Right.
Right, because farm operation still has to happen, and public, the public system still has to remain up and running as well. I get that. Thank you.
And just out of curiosity, again, would those be at at 75 feet? So if you wanted a co-locator, it'd be at 85, and then the next one at 95, or you can do it at every 10 feet. Is that what I understand? Because those are roughly 75 feet.
I think what you're asking is where on the tower would the existing equipment for the two poles at the property be located?
Yeah.
We're not prepared to answer that today. We would need some technical review of that, but we would work within the radio frequency needs of those tenants, and as well as the pole owner, to ensure that they had appropriate space on the tower. Exactly where it would be, I wouldn't be able to answer for you tonight.
Fair enough. Fair enough.
Okay, I see Susan Satori with your hand up. Can you state your name and address, please?
Susan Sartori, 465 Green Street. Can you hear me okay?
Mm-hmm.
Okay, thank you. So this discussion of the two poles over at 351 Ball Street, am I inferring from the conversation that if we had never brought this up, there would be no ability for the monopole being put forward at 409 to go up, because they would be in proximity of one another under a mile? Is that what I'm hearing?
I don't believe so, only because our definition of a WCF is and Amy, correct me, I know you had it in front of you, but it was a public or commercial, right? And this pole is a private for farm. And
what about the other pole?
Yes, the other one was already coming down. That was already a condition that
But
everyone had agreed to.
you're doing the applicant a favor by having a condition to have it come down. Because they would not be able to get their waivers if that still existed in that spot. Am I getting this wrong?
If,
It would be
I-
at cost to us. We don't see it as a favor. That is gonna cost us money. It's gonna take up space on our tower. So
No,
certainly
I
we
meant
we would
you'd
prefer
have the
not to have that
ability.
condition. We would prefer
Wh-
not to have that condition. But if
No, excuse me, I'd like to speak. Thank you. I'm trying to understand, is that pole as it exists now in a placement that would not allow you to be able to put the pole you want to put at 409?
If I can, I'll read our bylaw states on page 7-132. No more than one WCF, except co-locators, shall be constructed on one lot. In no event shall any WCF be located than 1 mile to any other such WCF unless the proponent can show that no existing space on the existing WCF can be leased or procured.
So at this point in time, have we done our due diligence to understand exactly the definition of the pole put in by the town of Boylston, I believe, for safety measures that comes in at the correct height for the aesthetics and for the bylaws of the town? We would take that one down to allow then one to be put up for 130 feet or more. I don't see how we've done our due diligence in understanding that particular pole and what it means. So I don't see why at this point in time you would feel comfortable saying yes to this and feeling good about that as a condition. I think we're also talking about camouflaging that pole. They're unwilling to do so. Painting it, the only way that it would make it fit in with the neighborhood aesthetic would to be camouflaged. It's going to have 4 stacks. No painting of any pole is going to change the fact that that is a huge pole in the middle of a field. It's going to stick out like a sore thumb. It is not going to blend with the aesthetic that goes on up and down Green Street and up and down Ball Street. We have had families that have donated land. We have had town resources spent. A lot of time and effort has gone into having this a conservation corridor for this area of town. And to allow a group of people that want more coverage in another town, and yes, some spotty coverage in our area that a pole someplace else could take care of, that we would get bullied into this because of fear of legal suits. The people that are going to be renting the space don't give back any revenue to the town for this, other than the taxes that they have to pay on the land already. We have taken stands on companies that have wanted to come to town that would bring large amounts of revenue to this town to have it work well for the neighbors. I see right now we're talking about making things better for the applicant. They will get rid of that pole and they can definitely win in any suit that's brought forward by the town or by them, because that pole will be taken down and put into the conditions. So I'd like for you to probably get some real solid clarification on the definition of that pole. I would really appreciate that as a resident. Thank you.
Thank you. Lori, you had your hand up?
Yeah, I just wanted to clarify that that co-location was for a WCF in 2023.
yep,
So that's how it was permitted. as a co-location on a wireless communication facility. So it meets the definition for a wireless communication facility.
And I thought so. So they're willing to relocate that one and take that one down. And I think, I'm sorry if I'm speaking out of turn, but obviously the landowners are the same people between one place and the other. One would think that there would be able to be some sort of a conversation that would, number one, say the landowner is in agreement to this, because that's one of the criteria of relocating and taking down a pole. Is that something we could get? Is the agreement that these poles could come down?
Well, yes, what we're saying to you is that we have agreement to take the one pole down. That was the pole that has the Boylston town on it. And we will accept a condition if you approve our permit to remove the other pole as well. And if for whatever reason we were not able to get an agreement to remove that pole, we would not be permitted to proceed with our proposed pole. So we're taking that off of the board's plate.
Okay. Okay.
Madam Chair, through you, can I maybe just make a
Sure.
suggestion?
Yep.
On a condition? So I think what I'm hearing is that perhaps the condition would include that at a particular date, maybe before pulling the building permit, the applicant would provide documentation that the necessary agreements are in place to do that work. And then there'd be a later date in the decision by when it had to be done, understandably after the pole is constructed, because nobody wants a disruption in service. So perhaps that's something you and the applicant want to talk about, but that might be for both poles, a way to address the issue.
Can I get a clarification who that was speaking? I'm sorry, I don't have it on my screen.
Sorry, that was town council. I apologize.
Okay, thank you.
Yeah, and
Yep,
I
there's Robin.
completely agree with that suggestion.
Okay, so Robin, Attorney Stein, does that put into the effect that if it doesn't come down, then they won't get the new pole too? So that takes that into account, what he had just said.
Yeah, I mean, I think that you can put language in the decision that the applicant has represented and agreed that they're going to take all the steps necessary to have the equipment on both poles relocated and both poles taken down, that the applicant offered, that they understand that if they're not able to accomplish that, they're not going to be able to use this permit. And that the condition would simply be, again, that prior to pulling a building permit, they provide the necessary documentation that they've worked out, having the rights to do that relocation with the property owner. And then again, just, a suggestion of timing. And I don't know if the applicant has an idea on timing, if you're talking, 90 days or what's a reasonable amount of time once you're able to move the equipment over to get rid of the poles, but you would build that all into the decision.
Okay. So if this does go forward,
So obviously,
should you work with Lori on that? And the attorney?
Sure. So I mean, again, obviously, whatever you vote tonight, there's going to need to be a written decision. It's going to need to get finalized this week, given your timing. And those are just things that, you would work in. Usually you authorize, one board member to work with your planner, and then obviously I can review it to get the decision done. So it would just get worked in based on this conversation.
The only additional point I'd make with that is you might want to include in the language for the decision that the cost that for the public safety entities on these towers, whether it's Boylston, who's on the pole right now, or Northborough, who might go on the pole in the future, that the relocation would be at no cost to the towns.
Well, we agree with all that except for one portion of what Mr. Lawton said. We have not agreed that Boylston would have free space on the tower. We do have economic considerations. I'm not sure what they're paying the current landlord, but we're going to have to make them whole. So we're agreeing to honor whatever their current arrangement is and to take care of the transfer of equipment, but we're not agreeing to improve the financial agreement that Boylston has. We will agree, because our pole is in the town of Northborough to provide free space for Northborough. We are not agreeing that the space would be free for Boylston, just consistent with whatever they are currently paying for their existing pole.
Does that make sense?
It does, yeah.
And does that
I
make
mean,
sense, Lori?
I wasn't considering the rent. I was thinking more of the relocation cost, but your point about the rent is valid.
Okay. Sharon, I see your hand is up. Is that from before, or do you have another question?
No, I have a new comment. So it is,
Could you just state your name and address
yep,
again?
Sharon Berube, 359 Green Street, Northborough. It is mind-boggling how we have even gotten this far since that 2023 tower is a WCF tower. And one of our bylaws is not to have another one within a mile. Mind-boggling. My other comment, I have absolutely no confidence in the board, the town, to follow up on conditions. The conditions from the 2023 poll still have not been met. It's shameful, really. So you can talk conditions all you want, but who's following up on it? We have a building inspector that says he has no time. We've brought up the issue. The conditions for the 2023 poll still have not been met. Nobody seems to care. So it's a moot point talking conditions. And the bottom line is we're still going to have a 135-foot pole in the middle of a field on our scenic roads, which the town works very hard to preserve. And you can cut it any way you want, but that is the bottom line. And I just think the board needs to think long and hard about it. We can go rounds about everything we've talked about. I mean, Mr. Lawton and his team, have had hours upon hours upon hours to present things, to repeat things multiple times, multiple meetings. The townspeople have had minimal time. We're actually the ones that pay the taxes in town. And I just think you need to think long and hard about it. Painting a 135-foot pole, I say don't waste your money on the paint. It's not going to make one bit of difference. And I think we all know that. So that's pretty much what I wanted to say. Thank you.
I think you meant Mr. Fenton, not Mr. Lawton.
Correct. I did mean Mr. Fenton, yes.
Okay, thank you. Is there anyone else with any questions?
Yes, sorry, couldn't put my hand up, but Adam Osofsky, 354 Green Street.
Okay, yep.
Thank you for your time. I'd like to express the same sympathies as Sharon did as well. I'm completely at a loss to watch this. Another almost 2.5 hours of back and forth. I don't understand. Is this a planning board, or is this a debate, or is this a opportunity to try and put a square peg in a round hole? There is many properties in the town of Northborough where this could go, not in a scenic route where taxpayers' money is being, again, property value. We could talk about it for hours. Does this give every person that wants to open up a business or build something a debate? I don't understand. I'm at complete loss listening to this. I almost feel like there's an agenda. There's an agenda. And prior to this, the discussion was, well, the town doesn't want a lawsuit. Again, I mean, what about the neighbors? A lawsuit coming from us after this. We take this video on YouTube in the court of public opinion to watch the back and forth and decide let's try and put a square peg in a round hole. What can we do to make it work for our client? I don't get it. I really don't. I mean, this is a 130-foot tower in a residential area. It's that simple. Again, I appreciate all your time. I mean, again, I know it's a volunteer position, but I just feel like there's an agenda here. And there's going to be some, whatever decision is rendered, I get it. But there's going to be some answers that need to be called out on that after the fact, because there's video showing the back and forth. I find it remarkable and very unfortunate. This is a great town with great people, but I do feel there's an agenda here, and it's extremely unfortunate. Thank you.
Thank you. Okay, any more comments?
Comments from the
Okay.
public or comments in general?
Well, it was from the public, but we can move on to the board comments again if we have no other public comments. Do you have any more questions? Anyone on the board?
For me, the question goes back to the waiver. Should that have been something that was discussed because it's it's a wireless facility within a mile of another one? And that's actually something that I had considered before, but was told that this was not a wireless facility. That seems to be a
I
bit of
don't
a,
think town council has the bylaws in front of you, do you? Because when I do read it, it says, in no event shall any WCF be located closer than 1 mile to any other such WCF unless the proponent can show that no existing space on the existing WCF can be leased or procured. So I guess what it would be up to,
So-
in my opinion, when I read that, is that they would have to prove that there's no space there.
or suitable space,
Can I
right?
just clarify? Because I think you
Sure.
were asking me about that.
Yes.
Sure. So my understanding is the two towers that may qualify as WCFs that are within a mile, as a result of this decision, are coming down.
That is correct.
So there will be no WCFs within a mile. It's going to be a condition of the decision. They're curing the issue. Am I not understanding that correctly?
No, I just wanted to verify with you that that was okay, because that came to our board like that.
I think it's fine.
And I
No,
just wanted to
look,
make
I think it's
sure.
fine, and I think
Oh.
again, so I think it's fine for that provision in your bylaw to get addressed through curing the issue by the removal of the other towers, so long as they get removed. And as you've heard, the applicant understands that if they're not removed, the applicant
Okay.
isn't going to be able to then operate their tower, which is why I think you put in the kind of benchmark of requiring proof that, you know, all the agreements are in place, everything's ready to go to take them out before they pull their building permit. And then, you know, you have that assurance. But ultimately, if they didn't come down, then they would have an issue because they would be in violation of your bylaw because they've not sought a waiver. They've sought to cure the issue, not waive the issue.
Okay, so then they wouldn't get a building permit for the new tower. The way the condition will be
Well, I
written.
mean, any condition in the decision that says prior to building permit, you must do X, Y, Z needs to be satisfied before you get the building permit.
Okay. So that's why they, yeah, okay, got it.
That's why I suggested a first step of prove you can do it before you get your building permit. Understanding the new tower needs to be up before the equipment can be moved over from a technical, practical standpoint.
Mm-hmm.
Okay.
If I may, Madam Chair,
Sure.
the question has come up. It wasn't posed directly to us, but I understand the desire to get it answered. How much time we would need after the installation of our tower to take the other towers down? I see that Igor from our team is on the call and Carrie. Can either of you give us an answer tonight for how much time we would need to be able to move that equipment and take those other towers down?
That's a tough one for me to answer.
Yeah,
Typically we try to do it within, within at least 30 days, I would think.
Who's that
from it
speaking?
being built. This is Carrie Fesolari, but I don't know. I can't give a definitive answer without
I
talking to my
think
construction guys.
Yeah, and I work in IT, so I understand completely. I think what we're looking for is more, are we looking at weeks, months, or years?
Months. I'm not the engineer, but I would be much more comfortable with 90 days. To
I
make sure,
agree. 90 days.
I
to
think
make sure we could comply.
at least I could live with 90 days. I don't know about the rest of the board members.
Board members, do you have any opinion?
I think 90 is reasonable.
Yeah, I'm fine.
Okay.
Just before we move on, Igor, can you just verify that I'm not way off base here? Is 90 days actually possible for us to achieve that?
Can you guys hear me? Yeah.
Yes.
Yeah, that's Igor Yevsuk, Structure Consulting Group, site acquisition for Verizon. But yeah, I mean, 90 sounds fine. It's question, it's mostly construction related question. I don't think any of the construction managers are on this call. But I do believe 90 sounds reasonable. Once the other tower is operational and equipment is moved, I mean, 90 days seems to be reasonable to just dismantle the existing towers.
Okay, thank you. If somebody who's not a lawyer who also thinks 90 days is reasonable, that was important.
Okay. So, anyone else have any more comments before I move forward?
I'm not sure if I can ask these questions, but it's more about the height that is necessary versus to meet the needs versus the height that's being requested. I feel that 130 feet is on the high side. That the coverage in service could be met with something considerably lower. That's not seemingly something you've been willing to consider, if I understand correctly.
No, that is not correct. We have considered at past hearings, we've provided alternate radio frequency maps showing the drop off in coverage if the tower height was to be reduced from what's proposed. And we submitted radio frequency testimony from C-squared engineers testifying to why that's not feasible in this case. And it would also be at 35 feet, one of the shorter towers in town.
At 135, yes. Certainly 35, but yes, 135. But yes, you submitted information, but I thought I understood that it wasn't something that you would want to consider.
We considered it, and it's our testimony that we've demonstrated why that is not feasible to have the tower at a lower height than is proposed based on our radio frequency needs.
Okay. Okay.
As I'm leaving it open, we can discuss as we go through it. If we go through, we go through the waivers. Oh, sure.
I don't know if my reference for that would be the plots that were provided that show the differing heights in the proposed height and then two lower heights and the coverage in the area. In the prior hearing, I was asked, was there a significant difference in specifically in Northborough? And my answer was, there, to me, the height doesn't demonstrate a significant difference in Northborough for the different heights. However, in Boylston and Berlin, there is certainly a large unserved area shown on the plots and in evidence when I drove the areas with my Verizon phone. The coverage in Boylston is and in the northern section of Northborough is deficient, and this tower would alleviate a portion of that, but not the entire gap, and it would resolve less of the unserved area or underserved area at the lower heights. So there is a significant improvement in coverage coming from the 130-foot proposal over the lower heights, according to the plots and according to my own samples in the driving around, taking test samples in the area.
So, but looking at those maps, I see that there seems to be a lot of overlap or redundancy in the amount in the area that's covered at, I believe it was 700 megahertz. And so I guess my question is, the other areas that are currently covered by, I believe it would be Verizon, will those towers be less functional, or is there double coverage in those areas? Because it seemed like that green area was significantly bigger.
Yeah, I
yeah.
think the best way I could explain that is all carriers, not just Verizon, any carrier has a set of licenses for operation, and their licenses can go anywhere from 600 megahertz all the way up to 3.5 gigahertz. And the propagation that you get from the same height, from the same, functionally the same antennas, from the same operation on the same tower, the propagation reduces by the frequency as the frequency gets higher.
Right.
So what ends up happening when you look at a network in a given area, you do often have overlap of 700 megahertz coverage. As new sites are added, it's incumbent on the engineer to try to reduce that overlap as much as possible. That's the job of the engineer. But in order to have contiguous or mostly contiguous coverage at the higher frequencies, there's going to be there's no real way to avoid the overlap. And there is some overlap that's necessary, because as you're driving along, you don't want, or as you're using your phone for whatever it is you'd be using it for, you don't want the coverage from one site to immediately end and require you to get to the next site. There needs to be some overlap for the handover process, or for your whatever you're doing on your phone or your device to be passed from one site to the other. It can't be the case where they just one ends and the other one begins there. So yes, I agree. There's a significant amount of redundancy on 700 megahertz, but that's not unusual in a wireless network, in a suburban wireless network. You'll see there's a lot less redundancy in the plots that they did at 2100 megahertz.
Right. No, I saw that. And so I guess my question became, well, if they did reduce the height, would that redundancy be lessened, but still provide adequate coverage?
Certainly
awfully significant.
And I think what I would say to that is that the applicants or the carriers would take the position that in order for them to provide effective operation of their networks, they need to be able to have coverage from more than one frequency band. So while the 700 megahertz or the lowest band of spectrum that they have covers much better and will have that redundancy, in order to efficiently and effectively operate their network in Northborough or wherever we're talking about, they need to be able to use the higher spectrum as well, in order to provide data rates that people are looking for and enhanced coverage that their customers are looking for. So it's not enough to simply have coverage from one band. They need to have coverage. They need to be able to use all the bands, or maybe not all the bands, but most of the bands that they have in their possession, that they have licenses for.
Can you possibly answer the difference? So the mapping that is provided is a radio frequency band, is that correct?
Yes.
Yeah.
Yes, that's correct. So they
So it's
provided plots.
computer generated, correct?
They are computer generated, yes. So the input is a terrain database, a database of the morphology or the ground clutter, and then the specifics of the heights, the antennas, the power levels, the any tilt that's included. All those things are included in a program simulates the coverage. And what the carrier should do, and all of them do, and in other municipalities, this is also used as a check, is go out and do measurements, drive around with test vans or test cars with phones in them, to validate these computer predictions, because it's to their benefit and to everyone's benefit, really, that these computer predictions be as accurate as possible. So I do a lot of work with the Cape Cod Commission. The Cape Cod Commission, that's a requirement of an application, is that they have to provide measurement data, and we look at the measurement data and compare it to the predictions. And in most cases, it's quite accurate. It's not perfect, but it's quite accurate. And I have no reason to believe, based on I didn't do an exhaustive drive test, but I did do some driving around in the Boylston and Northborough area, and I have no reason to believe that these predictions are flawed. So my recommendation is to take them as what they are, which is a simulation of what the Verizon network covers and potentially will cover in this area.
Yeah, and thank you. I agree with that. I feel that like I said, I just noticed it seemed like a lot of redundancy. Can you possibly kind of give us a little bit of an explanation between that, the radio frequency computer generated coverage, versus what I think something I've looked into is the FCC national broadband map, which seems very specific for very locations, for very addresses. And I'm just trying to figure out, what do we need? How does Verizon get what they're looking for? And how do the residents understand what we're agreeing to or not?
I'm sorry, I muted myself. I'm not, what question are you looking for me to answer? Should we?
So the RF generated computer prediction map is a little bit different, is a bit more broad than the national broadband map. And so the discrepancy, I would be curious to see if that smaller area, which is what it really is depicted, it's very defined and very refined, could be served by a different project proposal. Does that make sense?
Somewhat. I mean, there are other options to provide coverage. I think the applicant has represented and demonstrated that the existing sites in the area, including the TV tower, the tall TV tower that I asked about in Boylston, none of the existing sites are reasonably capable of providing the coverage in this area that they're looking for, or that they're trying to provide, that Verizon is trying to provide. And presumably AT&T and T-Mobile might come along afterwards and be interested in a similar type of coverage, because AT&T and T-Mobile are also probably on at least most of, if not all, the same sites that Verizon is on in the area. So is there something existing that could resolve this issue? I think the answer is no. And I think
I'm actually asking if the project could be proposed at a different height, and would it cover basically what is, considered, what is really shown on a more specific map as what is the deficit on the broadband map.
so. The FCC broadband maps, what generates them is actually the very same predictions that the carriers provide to the FCC.
Exactly.
And so they're not considered, again, this is similar to the marketing maps.
Okay. Thank you.
They're not, I wouldn't say they're as optimistic as the marketing maps, but as a source of valid technical coverage analysis, they're not as what's the best word I could use? They're not as robust as what an engineer is going to do, which is what the C-squared engineer did in this case on behalf of Verizon and presented to the board. So the wireless companies have teams of engineers on staff, and also consultants like the C-squared engineer, who are modeling coverage on a daily basis and looking at what if and how can they improve the network and that sort of thing. So what you have in front of you, what's been submitted in this application and through my follow-up questions, is output of the internal teams and the C-squared team to show the engineering, rather than, as was asked earlier, the marketing. We cover everything, you should buy our service kind of representation.
Yep. Thank you. I appreciate that. I appreciate it.
I just had a question while you're on. I think I heard you at the beginning, like when I started this, I did ask questions, would the 75 feet cover Northborough? And it was yes, because I did think that the significant gap as a Northborough Planning Board, we were in charge of Northborough. But then a month ago, when I asked for town council and did receive town council, she did verify that we do have to look at the whole gap, even though it crossed town lines. And so that is why I wanted to reopen the hearing. But what I heard you say is that the 75 feet looks like it would cover Northborough, but it does need to be taller. It would need the 130 feet or 115 feet or to cover the other towns or just the rest of the white gap.
That's correct. And I mean, I'm as I'm talking, I've been trying to find those plots. I haven't found them yet, but and I know Keith's not on. So, but what I was going to try to do is bring up those plots and let you see them. Basically, what my recollection of those plots was that the corner of Northborough, or the side of Northborough that we're talking about here, was maybe 10% of the white space or underserved space in this general area. And there's a much larger area in Boylston between the Northborough line and Route 70 that's not well covered at all, or sporadically covered. And that's the area, I think, where the height differential is most necessary.
And as hard as this is for me as a board member, it sounds like because they have a willing leaseor and no willing leaseors when they reached out to Boylston, the town of Boylston, that it makes it very difficult for us as a board. At least in my, I just want to say that because
Yeah,
I,
I mean, when you phrase the question about Northborough specifically, I can answer that question, and I think it's a fair and reasonable answer that if you were if the true goal here was simply to cover Northborough, I don't think Verizon would need it. They wouldn't be here asking for a 130-foot tower, but they're not. Their customers are in Northborough and in Boylston and in Berlin and in any other nearby city, and they need to cover the customers regardless of what zip code they're in or what town they're in.
okay, and you think, so you think, I was hoping we can meet in the middle. They want, our bylaw says 75, they're saying 130. When I looked at the plots, 115 looked close to 125, so I was hoping we
Yeah.
could bring it down. I actually was hoping that this meeting tonight would be a little more productive, working with Verizon as some, to work together towards a common goal.
Well, if you give me a second, I will find those plots and we can throw them up I'll share them on the screen and we can look, all the board members can look at them and everybody can see. And, instead of me sort of paraphrasing what I remember from the last time I looked at them, everybody can look at them real time and make their own assessment. But I'm going to need a second to find them.
I was looking at them today and I think with the 700, one or the other, either the 700 or the 2100 looked like, you really could come down to 115 feet and it's not that big of a difference at all.
I think it was a 700. I think I saw that.
But I'd like to see it from Mr. Lawton. Like you said, they need both frequencies. So
Can maybe Mr. Lawton can answer this? It's a sort of a clarification on what a term means, but I read that a site was rejected or certain co-locations were rejected because they weren't able to handle the offloading capacity, which what does that actually mean?
you're muted.
No, that they
Yeah, I
might-
was muted and because I was doing homework. I was trying to find the plots.
Oh, sorry.
Which I have found. So your question was about offload, and the sites were rejected because they wouldn't provide. Okay, so what they're referring to in terms of offload is you have an existing network of sites. Those existing sites cover and serve customers and usage. When a new site is brought up or a change is made to the network somehow, that new site absorbs some traffic, and some of that traffic that it would absorb is new, and some of that traffic that it would absorb is traffic that's already being covered by an existing site. So offload is, if a particular antenna or a particular sector or a particular radio is 100% at capacity and a new site is commissioned in front of that sector, that new site will absorb or take or provide coverage to some percentage of that capacity. And so the previously loaded sector pointed into that area will go from 100% utilization down to 75% or 50%. That's what's considered offload. So it's basically taking usage from a site that's already there, and that's why, going back to your question about overlap,
Yeah.
That's why the overlap is important, because if you have a sector or a site that is exhausted, that does have a capacity concern,
Mm,
then when you bring a new site, or you need to bring a new site in order to provide additional capacity, it gets to be a bit more complicated, because you sometimes the overloading can be at a certain band, and this is the life of an RF engineer at a carrier network, which is, how can I give customers a good experience on a band that provides coverage to where those customers need to be. So it's a sort of a multi-dimensional problem, if you follow the analogy there, and it's not as simple as just saying, okay, here's a plot and it shows it's covered, and so therefore it's covered and it's great. There's more to it than that.
Is it possible that sometimes that offloading can then create another gap somewhere?
If the engineer has done his job, or his or her job, no.
Okay, so we would ideally not be looking forward, not looking for the consequence of creating another gap somewhere.
Correct. Yes.
Okay.
The gaps, the gaps, if the engineers are doing their jobs, the gaps don't get worse, they get better.
Okay. Thank you. I appreciate that.
And I don't know who's sharing, but that's the one part of the picture. The part of the picture that I was also looking for was the demonstration of the coverage of the site, the proposed site, at different height levels. So, which is not, I don't think it's part of this presentation, if I'm right.
I think it's Lori that's sharing.
Yeah, I was sharing. I thought that's what you were looking for. But
Yeah,
I
so
just
that's
unshared, so if you found it, you can share your screen.
Yeah, so that what you were sharing was the demonstration of the existing coverage. Now, I hope you all are seeing what I'm sharing. Are you seeing it?
Yep.
Yeah. So these are the plots of decreasing height and the two different bands that were provided. So the first one is just 700 megahertz coverage, just from the proposed site, and at 125 feet above ground. And then this is just 2100 megahertz coverage from the proposed site at 125 feet. And is that it? I thought they did oh no, those are the single site. They also did a couple of other heights in composite. Now I have to go find those. Hold on a second. I have found them. I'm just getting to the right page. Okay. So these are the composites now, not single site. So the previous ones that I showed you were just the single site coverage. This is composite of existing plus proposed at 115 feet. And this is what I was referring to, that there's still I don't know if you can see my cursor as I'm kind of moving it around here, but there's still some white areas at 115 feet in Boylston. And this is at 95 feet. And the white areas are getting a little bit, this is 700 megahertz. These are both 700 megahertz. The white areas in Boylston have expanded, and there's a small white area in Northborough in the corner here, but there's actually no road there, and I'm not sure there's any houses there. And then if you go down to 70 feet, at 700 megahertz, the white areas and the gray areas get larger.
And I was looking at the Green Street to the right of the bottom too, like that's what gets bigger right there.
Yeah, that also, there's also along the, I think this is a river here, along the river that presumably a valley, there is a gap that.
So
you can
what,
see-
how many feet was that?
Okay, so let me go back up to the beginning. This is 115. This is proposed at 115, and you can see that along that river, it's not great, but it's somewhat covered. And as you go down to 95 feet, the white area gets bigger, a gray area gets a little bit bigger. Then you go down to 70 feet, and the white area gets a little bigger, as one would expect, and the gray area gets a little bit bigger. But also up here, these white and gray areas have also expanded as we've gone down in height. And then to your point, here's 2100 megahertz, and at 2100 megahertz, there isn't a lot of the same redundancy that that you were talking about at 700 megahertz. You can see that there's a good chunk of Boylston, in this sort of triangle here is still basically in a gap at 115 feet, and it's only going to get this part of Boylston at 115 feet is not seeing 2100 megahertz coverage at all, really. But the 2100 megahertz coverage in Northborough, has gotten smaller, and then here down along Green Street at 70 feet, it's there's a significant gap that opens up here on Green Street.
Can you put it back to 125? Do you have that there?
I do not have 125.
Okay, then we're on the same.
Yeah, this submission had 115. This is what they did. 75, 95, and 115.
Okay. So I feel the white is substandard, the gray is coverage that is for outdoor phone use, correct?
That's, yeah. White would be, you could probably make a voice phone call. Voice is less demanding on coverage than things like, data streaming or something like that.
Okay.
So you could, or text is even less demanding than voice. But you could, in the white area, you'd probably receive a text. You could maybe make a phone call, but you would not be able to use any kind of, higher speed data or anything like that. In the gray area, you'd probably have a decent phone call and you'd receive your texts.
Mostly for outdoor use, though, correctly?
Yes, gray is outdoor. And then the other two levels are -85 to -95 would be for coverage within typically that's considered to be coverage within a car. Using a mobile phone in the car is basically a cage and it attenuates the signal. So I'm sure people have noticed that as you, if you're standing outside of the car, your coverage is better. When you get in the car, the coverage isn't quite as good. So that the -85 to 95 provides some margin for that, the penetration of the loss of the car, and then -85 is is intended to be to provide some margin for to overcome the losses getting into a building. typical building, not a large industrial building, but typical home, something like that.
Mhm.
So Verizon would be looking to provide greater than minus 85 dBm coverage to a customer who wanted to use their phone in their home or in their business building.
Mhm. And so, is there a standard for what's required by either, I don't know, the FCC for what would be considered acceptable coverage?
There isn't. I think it's to each carrier, and what's necessary has changed as technology has evolved as well. And it's incumbent on each carrier to figure out what is required to serve their customers. The 10 dB steps between green and yellow and gray are they're like I said, they're margins. They're not specific. They're going to capture improvement in some percentage of buildings or in some percentage of cars that are driving in some percentage of streets. So there isn't a and that's why there's multiple levels here. There isn't a specific, if you're above, minus 87, you're good. If you're below minus 87, you're bad. There's not a specifically set criteria like that in this sort of thing, or that's been supported by courts. It's really just what coverage the carriers consider necessary, and can we validate that the numbers that they're providing or the thresholds that they're citing are valid and reasonable for the area. And I would say these are the thresholds that you're seeing here on these plots are consistent with the thresholds that Verizon has used in every other application throughout Massachusetts and Connecticut and Rhode Island and New Hampshire and Maine that I've been a part of. There's not any kind of sort of funny business about, oh well, we need this here because it makes the picture look better. They're consistent.
So you're saying that I guess what I'm, and again, if somebody else has a question, what I'm trying to get at is what is the Verizon threshold that is needed to cover what height would meet the Verizon thresholds?
I believe, in my reviewing this, reviewing the plots, these plots that I've just showed you and the other plots, I think that the coverage gaps that we see on this plot, even still are not completely mitigated in the areas in Boylston at 135 feet. So I think this is a case of Verizon.
This one's 115 feet, right?
This is 115 feet. Yes,
Right,
I could bring up the 135 foot one, but yes, you're right.
Okay.
But I guess what I'm trying to say is that this is a case of Verizon trying to cover as much of this area as possible, but realizing that they can't cover the whole thing. So,
So you're
does that justify, what I think the question you're trying to ask me is, is 65% good enough, or is 70% good enough, or is 80% of the uncovered area good enough? And I don't really have an answer for that.
Yeah, the question I always have is that whether it's a gap or a significant gap. Yes, there is a gap. is it significant, which seems to be one of the words that is included in the description and details. So, you know, we've talked about this before. I agree.
Mhm.
I'm just looking, and this is helpful to give me a better idea.
I think, you know, the word significant is very difficult for engineers because there's no quantifiable definition of significant.
Right.
Your significant may be different from Amy's significant, may be different from my significant. And what's significant in Northborough may be different than what's significant in New Braintree or Athol or
Yeah.
Cambridge.
And
So
yeah.
it's hard to, you know, put your thumb on what exactly is significant.
Yeah, I kind of wish they wouldn't put that word in there. Anyways.
Okay, but you think, I know now that for Northborough, 75 feet is enough, but it's not enough to cover this gap. And so you feel that, oh, you're muted.
I muted myself again. Yes, that's correct.
Sorry.
I don't know. No, it wasn't you. It was me. I don't believe that that 75 feet is going to cover a lot of area and we've seen it on the plots in Boylston. Is it going to cover a good chunk of area in Northborough? Yes, it is.
What about in other towns? Is 130 feet normally considered what they ask for in residential areas, or I don't know if you can speak to that.
Generally speaking, you know, whether it's residential, suburban areas, 135 feet generally, you know, I mean, and I haven't really done a, you know, a plot, an analysis of this, but I would say 135 feet is generally pretty low. You know, a lot of the towers out there, including the one that I'm going to butter to, are a lot taller than 135 feet.
All right, Millie, if you don't have any more questions, I see 2 hands are raised, so I'm gonna take the questions from the residents. Larry and Kristen Blanchard, I saw your hand up first.
Yes, hi, Larry Blanchard from 366 Green Street. This may be a dumb question, but when we look at gaps in coverage and we look at that map of Northborough, Boylston, and Berlin, is that map specific to Verizon coverage only?
Yes, it is.
Okay, and that my second question is, and again, I know we are looking at marketing maps, but it appears that AT&T covers Boylston very, very fully covers Boylston. So if AT&T is covering Boylston, is the court measuring a significant gap by carrier, or does the court and FCC want no significant gaps in the overall network of all carriers?
I think that the way I would answer that is, you know, each carrier has the right to provide, or the right and responsibility to provide coverage and not have significant gaps. So the fact that if AT&T does have better coverage in Boylston than Verizon, the standard isn't that and that there's a term of effective prohibition, and the effective prohibition, you know, if AT&T somehow has coverage, or if AT&T doesn't have coverage, if Verizon is prohibited from providing that coverage, then, or from providing any coverage, then the gap is specific to them. And the prohibition would be specific to them.
So my question, I guess, too, is though, if AT&T has coverage and Verizon has a lack of coverage and gaps in their coverage, we talked about AT&T co-locating on the potential Northborough pole. Why couldn't Verizon co-locate on the AT&T pole or whatever AT&T is using to provide service in Boylston?
And yes, so that if we wind the clock back, the best way I would answer that is if we wind the clock back to the beginning when I first reviewed this application, one of the things I did then, and I always do, is look at the FCC tower database to see what towers exist and who's on them. And the only tower that I found that exists that Verizon wasn't on was the TV tower, and I forget the call sign of the TV, but it was in Boylston near the golf course. So I asked, I'm sorry?
I said that would make sense. It is near the golf course. I play Cyprian all the time, so.
Yeah, so I asked the Verizon engineer or the C-squared engineer to do plots showing coverage from that tower specifically, and he did, and that would not that tower or use of that tower would not resolve the area that we're talking about. Now, would it make coverage better in sort of the south central part of Boylston? Yes, it would. And would it improve Verizon's coverage in that part of Boylston? It probably would. So based on that, I would guess maybe AT&T is on that TV tower or something like it, which is what's making their coverage better in Boylston than Verizon right now.
I would think the board might want to look at that study or that study in greater detail to see how much that would close any perceived gaps in the Verizon network.
I think, Mr. Lawton, you did that, right? They did
Yeah,
that
I
on
did.
that
I
tower?
asked them, and I'm gonna try to find the
Because again, I'll just say, as a resident, you drive down Ball Street and in our face every day is the Channel 27 tower. So I can tell you, it's a line of sight. It would be line of sight communication with any antenna on that tower. So it should serve certainly the needs of Northwest Northborough and certainly serve the needs of Boylston because it's in Boylston. So common sense, and I don't have the equipment to measure the coverage, et cetera, or the expertise to do that. But common sight would tell you that would probably be as better sight than putting a tower on Ball Street, or Green Street.
yeah, so it's WUTF, I believe, was what I found.
It would certainly be higher. That's in that case, height is not an issue because that tower is obviously significantly higher than 135 feet.
Yeah, so this is what what was provided in response to that question. So this is existing coverage from for Verizon. Same surrounding sites that we've shown, and then this is the WUTF TV tower. And you can see, I don't have a side by side to compare, but you can see certainly it does make coverage between 140 and in this area it does improve coverage compared to what we saw, but it's not doing much up in this chunk of Boylston.
Okay.
So.
Well, I appreciate.
And then this was 2100, same thing, same site, same plot. It does cover a good chunk, just sort of north and east of 140 here, but it is also very close to a site that Verizon is already on called Boylston Relo. I don't know particularly where that site is, but it's quite close. But it does stretch coverage further north, but not up into sort of this triangular area.
And again, just a common sense question. If you were significantly higher on, I call it the Channel 27 tower, but if you were on the Channel 27 higher at a significantly higher level, elevation or level, I guess. Why is it projecting less than the 135 proposed tower on Green Street? Green Street looks like it does do a better job for Boylston, but that makes no sense to me.
It's really what's surrounding it. When I described how these plots are generated, they're generated based on the terrain. So there's a database of the ground elevation surrounding the sites or throughout the whole area.
Okay.
And when the engineer does the modeling, the program will look at the terrain and model the coverage based on both terrain and as well land use. So things like if you have a dense urban cluster or a railroad or open space or forestry, those all will affect the coverage differently in the way it's shown on a plot like this. Because signal propagation is better in some cases in some environments than others. Obviously, dense urban is the most difficult.
Right.
But we don't have dense urban here really to talk about. But an open space is going to provide better propagation than a forest because the trees attenuate the signal.
Yeah.
That's all that is incorporated within the simulation that's done that generates these plots.
Okay. All right. Well, I appreciate your patience. One last comment, I guess, and that is that, I think we go back to the certainly the height restrictions for towers and the setback restrictions for towers were laws that were bylaws that were passed by the town to protect the character of the town and the quality of life in the town. What I guess I don't see here is we're making a lot of compromises to try to make compromises to get this tower up, but I still think that does not take the concerns of the residents or the concern for scenic roads or the concern for quality of life into account. I'm not sure we've solved those questions or issues. I think those still exist with the residents. So I appreciate everybody's patience and time. Thank you.
Thank you. I see John Cogswell. Can you please state your name and address?
Sure, John Cogswell, 483 Green Street. And really just Larry just kind of summarized it beautifully. I think, first of all, thank you to the board and to Mr. Lawton for all the effort that unfortunately you've had to put into this. Yeah, it's just an industrial structure is not appropriate in residential zone a scenic area. It's not in keeping with our bylaws. And I do feel as though we're making a lot of effort to try to accommodate Verizon and to some extent Tower Code here by trying to figure out other options. Honestly, 135, 125, 115, it doesn't matter. Brown, steel, it doesn't matter. It's not an appropriate structure according to our bylaws for that location. And in terms of their need for better coverage, I think it's very clear that this opportunity fell into their lap via Tower Co, via the landlord. And I think it's one of those situations where, we are, like I said, trying to solve the problem for them. And I think, one of the questions I think I had was, we just had a big discussion about the 50 additional feet that are potentially available for a tower once it's installed to be extended, or some amount of feet that it can be extended. And so when we look at this map, and as Mr. Lawton was showing, I'm looking at the other tower locations, not to mention the TV tower, and it just says to me, fine, have they fully vetted extending those other towers to meet this need, this burning need in the rural roads of Boylston, to make sure that people can stream the latest show on Netflix. So I just think it's fundamentally an inappropriate use of the land and in violation of our bylaws and shouldn't be approved. Thank you.
Thank you. Attorney Fenton, I see your hands up.
Thank you. I just wanted to make two quick points in response to some of the comments that have been recently made. I'll be very brief. This opportunity did not fall into our lap. There was extensive due diligence, and we've been working on this site since 2016. And in terms of the radio tower that was referenced, one of our consultants messaged me during that testimony and stated that he does not believe that AT&T is located on that tower or that it could even accommodate our antennas. So based on the radio frequency testimony that we provided, we do need this location, this general location, and we've described why it has to be this particular location. And we do need the height as proposed of 135 feet.
Okay, any more questions or comments? Except for as a town, we need a little more. I know you say you need the height and the location. We really need a little more aesthetics. That's what's really hard for me to comprehend, because everything talks about the 75 feet and the aesthetics, and I know I'm going in circles, but it's really important to the town and to me as a board member. So I mean, it's very hard. It's a very hard decision.
We appreciate your serious consideration, and at the risk of beating a dead horse, we are agreeing to take down the 2 poles on the site. We are agreeing to paint it. We are agreeing to landscaping. And it's our testimony that it is by industry standards, a shorter than average tower, and one that will, despite the fact that it is not invisible, it will be seen by certain folks in certain parts of town. There is no way to make a tower completely invisible. It will have minimal impacts overall in the town from a visual standpoint.
I know, but I don't know what town you're from, but in Northborough, up there near Tugas and Davidian, it's like a big source of tourism, and I already brought it up. And not only for the residents, but for the people who visit, it's really going to be an eyesore. So it's very disappointing that, that we can't negotiate some way to have a little more aesthetics, whether it be the tree or the silo. And we can't even go forward with it without even seeing the costs. We're saying it's an extreme difference in price, but yet we can't tell you what that price difference is. And I know I didn't finish before, but when I looked up, I know everybody snickers at ChatGPT, but when I asked the price difference between the silo and the pole, it said that the prices of metal and the prices of concrete to put in that huge footing and put in the metal structure, at least according to this, it said that the price of doing the silo in the barn wasn't that much of a difference. But without any numbers, I can't tell.
And I understand that, Madam Chair. I can tell you that reference that you provided is completely inaccurate. It is a really material price difference. In fairness, if you had asked us the question in advance or at a prior hearing and told us that it was something you wanted us to answer at a future meeting, we could have been prepared to do that. We're not in a position to do that tonight because it's the first time we're hearing that question.
Would you agree to 2 weeks on the shot clock just to get us those final answers? I mean, we meet again on July 14th or 11th. I'd have to look it up. No, August. No. August 11th. I mean,
I think the answer to that is no, but I will let Carrie answer that.
I would also like to see if I can get dates and emails of the communication for the attempts to reach out to other feasible options. And in answer to a person's call-in on who was actually reached out for, it was the Boylston Planning Board, which we have an email, no email from, but a name of Corey Vaccaro. the Haven Country Club, which did have an email, so I'd love to see if I can get a copy of that. The Tugas Farms, which was an email, love to see it, get a copy of that. And no information on any reaching out to Davidians. So I'd love to see if I can get a copy of those communications. And again, I'd be more than amenable to just 2 weeks and hopefully help me make the best decision, the right decision.
Do you feel, Ms. Milton, that if we provided that information, you'd be inclined to support us?
I would be inclined to believe you did due diligence to look at other and communicate with other alternatives. I do believe that those might be the only feasible ones, and I would just love to see that what you stated is supported by emails. If I'm going to be asked to override my bylaws and, you know, again, disregard some of the intentions that the people in Northborough had voted for, I want to have good standing on why I did that.
I think the answer to an extension on that basis is no, but the client has to make that decision. So Carrie?
Yeah, we're not inclined to extend the shot clock for information that we've already provided and testified to. And in terms of providing the amounts for the difference between the silo costs and the monopine and the tower costs, it won't make a difference because we're not changing those amounts.
You didn't actually
Will not
provide the information
pass.
on the emails. You didn't actually provide it. You just listed them as, you know, communications. There was no date, no emails provided. So you said you did, or it was identified as being done, but I have no evidence that says it was actually done.
And we testified to it, and that would make us liars if it hadn't been done.
I would just like to know the dates. And I'm not saying you're liars. I'm just saying if I'm going to be asked to override the bylaws of my town, I really want to know, I want to have a good standing as to why. And to me, due diligence is a big piece of why this is, you know, before us, that's contentious. If that's not able to be provided, you know, I'm going to struggle with this.
It's able to be provided, just not this evening, and we're not willing to extend it. You've had the information about the outreach for many months, and we're hearing this request for the first time tonight. We can't comply with it tonight, and we're unwilling to extend.
Because I think, I mean, that was where we were headed last meeting with the feasible alternatives and due diligence. So I can see why she's asking that question.
We have been honest and transparent throughout this entire process, and we've complied with every single request for information that the board has made, and we have made every accommodation that the board has requested, with the exception of camouflaging the tower as a silo and building a barn around the equipment shed, or disguising it as a tree in the middle of a field. Those are not remedies that we think are appropriate financially or otherwise in this instance. And the questions that have been presented tonight, that we do not have the information to answer those questions. Again, it's not that we would be unwilling to answer them. We can't do it tonight, and we're unwilling to extend.
And so we have granted extensions for almost 2 months. At the expense of our own ability to get information. And I just want to point that out, that 150 days was given to us, 75 days was unavailable.
We dispute that characterization, because had the board insisted that we appeared on those prior dates, we would have done so. Again, we were also working on this site actively. We hosted a community meeting at the Northborough Public Library in person to accommodate abutters who had reached out to us in advance of the first hearing. And we were corresponding and responding to the pretty extensive report that we received from Mr. Lawton, all of which happened before the first hearing. That meeting that we had with residents was in person. In part, it was requested because this board meets exclusively remotely, and because we wanted an opportunity face-to-face to discuss with the residents the questions that they had. So it was not wasted or unused time. It was well used
That
time.
was May 12th. That was May 12th. The application was filed March 5th. That's 2 months that we were not able to basically have a discussion with you.
That is not true. We did not refuse to appear. We, at the board's request,
No.
we did some rescheduled balloon floats, some of which were due to the weather, some of which were due to the unsatisfactory nature of the balloon tests.
None of it which was due to our basically request. We did not request, you requested. But that's neither here nor there.
We have appeared at every single meeting that the board has requested, including this meeting, which is after the board closed its public hearing.
Okay, fine. We're going to disagree on that, but when you request a continuance and we agree, we were ready to meet.
I have a question for Attorney Stein. Is that something that you feel is unreasonable to ask for 2 weeks just to ask for information due to due diligence? Or you might not have had time to look at what they submitted, but in the first initial application, it was somewhat of a 1 or 2 page blurb that they reached out to Boylston and Boylston didn't respond. And
There
then
was a one page blurb, and that included Haven, Tugis, Davidian, and Boylston.
I don't know if this is a tough question
It's
to
really
ask,
not
but
a legal question for me. Well, it's not a legal question for me to say whether or not it's reasonable for you to ask or them to give or not give an extension. The reality is you have 150 days that runs this weekend. And so if the applicant is not interested in giving an extension, not willing to give an extension for whatever reason, then in my opinion, my recommendation is that you need to complete your deliberations and vote tonight based on whatever information you have in front of you and what that means to you, how you apply the bylaw, how you apply the TCA to the information that you have, and then file your decision.
Towerco would be open to extending your deadline and tolling the shot clock for a week, an additional week.
our planner is on vacation next week. Lori, aren't you? So like the next meeting we called was for the week after, I think. That's the only reason why we would do. Lori, do you remember when our next meeting is? It's the 11th of August?
That's correct. August 11th.
And you're on vacation next week?
Correct.
Is there any way you would go 2 weeks to August 11th, just so the planner can be here? And she takes record of, all the information that comes in.
Give me 2
So
minutes.
if I may also though, I think if you're talking about extending the shot clock, you have to keep in mind that if you extend it to the 11th, that's the day you would have to file your decision. So whatever you might be willing to extend the shot clock to, the board's going to need a couple days to, finish writing it up and get it filed. As far as how that factors into the discussion, but I can tell you, if you're looking for me, I already have a meeting every single night next week. So
Wait, yeah. Are you free on the 11th?
I can do the 11th, but again, it's between you and the applicant. If you're going to do, if you're going to continue to have a final session of this on the 11th, I still think you want, to the 14th, to the end of the week, to be able to write up and file your decision. And that's really up to the applicant.
Is the applicant amenable to that?
I think we'd like to have a decision on the August 11th, and then you would have additional days to give us the written
Right,
decision.
that's what we would, till the end of the week to
Well, they
write the
would-
decision.
Yeah, they would vote the 11th and they would just need to the end of the week to get it filed with the town clerk.
Yes, we'd be open to that.
So the
Yeah.
extension would be to the 14th.
Okay,
I'm not the only stakeholder. Other people can
If
can
if
help.
that,
But I do have a hearing in Greenfield on the 11th, so there's no way that I could participate.
Will the public hearing be closed as of tonight?
no, because I think she wants the information. So
well, the only
I
problem
did
with
get,
closing the public hearing is that they're,
Is the 10th a possibility for a meeting? I also have a commitment on the 11th to cover for my.
10th. And we are gonna leave it open because that was what happened last time, like when we're deliberating and writing the decision, it's best to have the hearing open still. But I can do the
I'm
10th.
available on the 10th, if that's helpful to you.
And board members,
Yes, I can.
I didn't hear what you said.
I said yes.
Oh, you can. Bill, can you?
I think so, yes.
We have to make
So
sure
we're
we
gonna
all
meet
can
on
make
the
it.
10th and the 11th?
Yeah,
I can
Yeah.
do it.
I'm on vacation too, but I'll meet. Which stinks. But hopefully the 10th will be quick. I mean,
Again, it sounds like Ellen can cover for me, but I have a hearing in East Hampton on the 10th, so I can't make
on the
that.
10th.
Yeah.
That Ellen will cover.
Yeah, I'm available.
All right, Lori, are you available on August 10th?
I am.
Okay. So I think, if we want to move it to August 10th, we have to, make a motion to continue the shot clock.
Wait,
And-
but
Oh.
Amy, before we do that, I want to make sure we have all of the questions that we need to ask asked now, right? So that way we know what information needs to come in, because what I don't want is I don't want another set of questions to come in on August 10th. We're out of time.
I agree. I think
So-
Millie had listed what she wanted.
Is the applicant clear on what I'm looking for?
Could you provide
No.
a written
Sure.
list of questions
Sure,
so that we
absolutely.
have it, and then everybody will be on it?
It's
Uh,
pretty simple. I'll get it out to you probably tomorrow, if not later on tonight.
Thank you.
Could I also have a written email from Carrie extending the shot clock, ideally to the 14th?
I can send out I'll send out a tolling of the shot clock letter. I'll probably do it tomorrow morning because I'm a little wiped out today.
Understandable.
We should make, a motion at least to extend it, or else, we don't want it to run out without
Right.
having something voted on. Like,
I think if it works for you, when you're ready, you can have a motion to continue the public hearing till August 10th at 6 PM by Zoom, and to agree to a shot clock continuance until August 14th. And then when you get the writing in, you'll file just the acceptance with the town clerk.
Okay. Is there anything else, like, Deb, did you state that you wouldn't be able to get the price difference between the tower and is that something you would get for the 11th or no? Or the 10th?
I don't think it makes a difference. I can ask if they'll
Okay.
provide it,
If
but
you
I
could
don't think
ask
it'll
if
make
they
a
could
difference in
provide
our
it, that would,
decision.
yeah,
Okay.
it would be helpful.
Yeah, I think, Amy, the other thing we need to consider, right, if you're gonna ask for a, a building and a smokestack, right? There's ongoing maintenance costs for that. You don't want, 5 years from now or 10 years from now, the paint to be peeling off of that. So you're gonna have to take, when you consider your costs through Chat GPT or whatever, you got to consider those additional costs.
Mm-hmm.
So I would be careful of, of what that true cost is for something like that.
It's a good point.
So muted. Okay. So I think we'll wait to vote and we'll vote on the August 10th. So do I have a motion? Now, Attorney Stein, do I take a motion by the board and then ask the applicant to agree? Or to continue the shot
So I
clock?
think, I think the applicant has agreed. The applicant has said, so I think it's in the record that the applicant has agreed to have this heard on August 10th at 6 PM by Zoom and has agreed to give the board until the 14th to file their written decision. And I believe the letter that's going to come over on the shot clock is going to be till the 14th because that'll be the filing of the written decision. Am I correct on that from the applicant side?
Yes, and you'll have it tomorrow morning.
Okay,
I see
thank
you
you.
nodding, Michael. For some reason, your audio is not coming through. Okay,
Yeah.
so I
Okay,
think in that case, the board can just have one motion to continue the public hearing to August 10th and to agree to the shot clock extension to August 14th. And then when the writing comes over, Lori will just, sign on it or acknowledge that it was accepted by the board and can file it with the town clerk.
Okay, do I have a motion by the board to continue the hearing of 409 Green Street to August 10th at 6 PM via Zoom and extend the shot clock to August 14th?
So moved.
And just, Madam Chair, if I may, before you take the vote on that, just so I'm clear, Millie will send us a list of questions at some point this week.
Yep.
And then in addition to that, you would like us to explore whether we can get back to you regarding the price differential between your proposed faux silo and barn and the existing monopole design. Those are the only two issues.
Well, that and I think you had agreed to a condition about the planting, so I don't need anything on that. Is that true? Like, wasn't that a condition Lori sent out? The street plantings, and earlier tonight you said you were okay with that?
We agreed with all the conditions except for the conditions related to the faux barn and silo.
Okay, and you agreed to the two that Attorney Stein had also brought up. I think it had to do with the
Yes.
extra 20 feet,
Yes,
Mhm.
yes.
and there was a second one.
We agreed
So
with the
I-
condition regarding the extra 20
90
feet and the removal.
I
of
had
the
mentioned the
second
extra
panel.
20 feet as well as the
Removing the
timing,
poles.
yeah, on the removal.
Yeah, the
Simple.
timing in the two towers.
Okay, so maybe we
Yep, the
could get
timing
that
of how
all.
that'll work.
And maybe,
Yes.
Lori, can you get that all together and send it out to them tomorrow? So,
Sure,
the
I
next-
I can work with Robin on language for the building permit condition. I'll
Yes.
send that to you. You can help me wordsmith it. And then
Yes.
I'll send that out to all parties.
Amy, I have a question. It looks like there's a hand raised in the audience.
Sure.
Is that something we should consider?
Sure. Sharon, are you raising your hand?
Yes.
Can you state your name and address?
Yep, Sharon Berube, 359 Green Street, Northborough. Is there any way you could get the residents a list of all the conditions that have been agreed upon?
Lori, is that possible? Is that public record now?
Well, I don't have a list of all the residents, of course.
Well, you don't need one of all the residents. You could just post it on your website or make it available down at town hall. But to have one list of what all the conditions are would be nice to be able to see it, since they're all being referenced, but there's doubt and questions on what exactly all these conditions are.
Is that, Attorney Stein, is that something legal? I mean, when we deliberate, conditions could change, be added, deleted, so
Yeah.
it's not.
No, I mean, you can,
No, I get
Sure.
that, but even
It-
amongst the board, you have
it's
different
up to you, but
questions.
there's no
No, I was gonna say, I get that you can change them and maybe, but
So
even amongst the board, you have different questions on what the conditions are. So to get
Okay.
them all on one page would be very helpful.
Okay, Attorney Stein?
So Amy, I think it's fine. I think it's fine if the board, once Lori and I have a chance just to get the language of the last couple in order, just posts, these are the conditions as of, 7/28, and understanding that they may change through the board's deliberations, but this is what you're working with. I think it's fine to include that in the folder on the planning board website that has all the other filings for this project in it.
Okay, sounds good.
Thank you.
Okay, thanks. Okay, so I made the motion. I don't have to make it again.
Yeah.
And,
So moved.
It's been made. And seconded, I believe.
Second,
okay, roll call vote, Bill Pierce,
Aye.
Anthony Zaitin,
Aye.
Millie Milton,
yes, and thank you
and,
for.
and I'm an aye. Okay, so we'll see you on
Okay. We'll
August
see you on the
10th.
10th.
Good. Have a good night.
Thank
Good
you.
night. Thank you.
Again.
All right, everyone, have a good night. Thank you.
Thank you. Okay,
Hey, Carter's back.
Hello.
hi.
Didn't finish it.
Okay. So, next on the agenda is public hearing continued for 10 Goddard Road. The application for a special permit for a non-residential accessory use groundwater special permit and a special permit with site plan approval submitted by Saint-Gobain for the construction of a temporary gravel parking lot and laydown area of approximately 39,200 square feet. Okay, welcome. I see we have Rick Berry from Saint-Gobain. I'm not sure. Oh, Michael Tortilla, sorry.
Sorry.
I'm not sure who's speaking and if there are other people here for your presentation.
Sure. So Michael Totor, Civil Environmental Consultants. As you mentioned, Rick Berry is on from Saint-Gobain as well as Don Murphy from Saint-Gobain as well.
Okay,
So
thanks.
just quick summary. So the last hearing, as you all may remember, was back in June 9th. We initially presented the project. Since that hearing, we've taken the board's comments and feedback as well as Ms. Connor's comments and updated the site plans to basically update the lot from being the gravel lot that was initially proposed to an asphalt lot. So the design has been updated with the stormwater to accommodate such change. Additionally, we initially submitted those revisions back on June 22nd, at which point the Tetra Tech peer review was also issued. We did receive Tetra Tech's peer review last Wednesday, so we have not had a chance to respond formally with revised plans and a updated stormwater report. However, we have reviewed the comments and we have no objection to making the revisions Tetra Tech has requested. So the one item we would ask for relief on from Tetra Tech's comments was regarding the timing of the test pits. Tetra Tech asked for revised test pits to be completed in the location of the proposed infiltration basin. Previously, we had done test pits further south on the site where the permanent basin would be with the larger development. Those test pits, along with several other borings that were done on site, were showing very consistent soil materials and groundwater across the entire site. We'd be asking the board for just relief to delay the timing of those test pits to be complete at the time of construction just to confirm the soil conditions and groundwater. So The location of this proposed basin is up gradient, upslope of what was previously completed, further away from the wetlands. So we feel like where this basin is going, it would still be consistent materials as well as groundwater at the lower depth, giving us the appropriate separation.
Lori, do you have any comments on, I know you had written a letter and you've reviewed Tetra Tech's.
So one of my major concerns has to do with the stone dust walkway. So I did put as a draft condition for discussion for this evening that they would modify the site plan to depict a 5-foot wide, 4-inch thick concrete walkways on an 8-inch gravel base in lieu of the stone dust. And the reason for that is at the last public hearing, they said that they are anticipating that this temporary parking lot be in place for 5 years. And stone dust walkways don't do very well over time. And of course, this parking lot can accommodate as many as 66 passenger vehicles. So that's a lot of traffic using those stone dust walkways. There are a couple of areas adjacent to the driveways where the slope is kind of steep. So I think it would be better, certainly long-term, they have to do concrete sidewalks anyway. So why not do them right the first time? It'll be less maintenance for the Saint-Gobain. And then it's something that they won't have to worry about doing when they do the permanent parking lot.
And I'll say I did speak with the Saint-Gobain team. We're amenable to that condition, to revising that as part of the application.
Okay, sounds good. The
So
board
everything
members have,
else that was outstanding, I put as conditions of approval, including addressing Tetra Tech's comment letter. I mean, ideally, I always like to see the test pits prior to construction activities, because of course, part of the construction is to do the basin. So essentially, when you're talking about you want to do it during construction, at what stage are you talking about?
We can do it right after the tree clearing, where it's easier access. That would be the
Okay.
stage we propose to conduct test pits.
Okay, I'd be fine with specifying after clearing, that's when you'll do it.
after clearing and then before construction, right?
So you'd still be doing, so the clearing is part of the construction. But they're not doing the grading activities at that point. So it would be after clearing, but before grading activities.
Are you amenable to that?
Yes.
Okay. Do any board members have any questions for the applicant?
I have a few questions.
Sure.
In my note paper here. So with the waivers, I think there was the parking and traffic, the lighting, landscaping, and development impact. Are those going to be included either in the master plan update as a kind of bigger scale, or with the permanent parking lot, things like the lighting and landscaping?
The lighting and landscaping certainly, as part of the larger development parking
Okay.
lot, would be included. The traffic and the development impact statement at this time's not being considered to be included, as it was part of the original master plan for what the overall impacts of the site would be. If the board's looking for an update to that, we can certainly look to include that information.
Okay.
Yeah, there was a condition of approval on the additions saying that you have to update the master plan. So that would be the expectation, is that you are updating the development impact statement as part of that.
Yeah, that makes sense. It's a small project, but once you do every little small piece of it, it turns into a big project. So that was one. Another question was just with the findings of fact number 5, where it mentions that the temporary parking was part of the 2007 master plan, but I mean it was a permanent parking. That was just sort of the wording of it didn't make as much sense to me. I don't know if it matters to change that at all, but
If you want me to adjust the wording, I'd be happy to do so. Just tell me how.
yeah, I don't have it up with me. I mean, can maybe find it just to talk about it, but
Said temporary improvements, maybe temporary improvements leading to future permanent. Because that's what I find too. It's like this is temporary, but in the condition, in the decision, they have to come back for a permanent, right?
How about it, because it's kind of facilitating the permanent parking lot. So it's like the first step in the 2-phase process. So will facilitate the full build out master plan where a permanent parking lot was proposed. Are you okay with that?
Sure.
So it would say the temporary improvements proposed in this application will facilitate that full build out master plan where a permanent parking lot was proposed.
that sounds good. And then just for the conditions, one, just to clarify the 5-year on condition Q, is that effective from the approval? So is it today or when it's filed, or is it from when construction starts?
I had put it as the date of this approval, which would mean today. But if you guys want to pick a different date, then I'm fine with that.
I was just knowing because like they have 2 years to start construction, so I didn't want it to turn into, okay, you start construction 2 years and then it's another 5 years after that you're still doing it, but that's fine. And then
I can put in parentheses the date if that would clarify it. So it'd be July 27th, 2031.
Sure. I remember there was just a part on it that was in red. There it is.
Whenever I put something in red, it's kind of as a reminder to myself that that's a question.
Okay, I was just I don't remember exactly what it was. It was in condition B. And I was just wanted to check, was that something agreed on or not?
Oh, that was, the question. That was my reminder to myself to mention that I am suggesting that they do a permanent walkways as opposed to the stone dust. So that's why I did that.
And then my last 2 questions. One was just because it's a temporary one, but it, 5 years, which was again longer kind of for some things, but would they maybe like give an update at some point within that time of when they're thinking it might be a permanent one instead of the full 5 years, that we're not kind of waiting for that?
I think, Michael, you said that your plan is to come within the next year with the permanent parking lot design.
Yeah, we'd be working with the Saint-Gobain team on the permanent parking lot design to bring that before the board. Obviously, that we'd bring it before the board ahead of the 5-year timeline in order to meet the condition of construction starting within the 5 years.
Okay, that sounds
So you
good.
okay with that, Carter? And you're
That's
okay with the
fine.
5 years too? Yeah.
And then my last one was with condition C about the timing of construction. Considering that there's been a lot of discussion about changing daylight saving time, I was wondering if it would make sense to reword that to be like either 7 o'clock or sunrise, whichever is later to start construction, if that's something, again, just to.
To me,
Because
I would
again,
leave it. It's in the
This is in the
bylaw.
zoning.
Okay, okay.
So I don't think we can easily change it. The building inspector has just asked in every decision that we put the hours for construction so that people will be aware.
Okay, then that might be just, that's a suggestion to look at in the future. Those are all my questions.
Well, thank you for the questions. The board members, any other board members have any other questions?
No.
And Lori, Josh didn't, Tetra Tech looked at it, but Josh didn't have anything to add.
And he sent me an email saying he was all set.
Okay. All right. I don't have any questions. So do you feel that we're ready, Lori, to go forward with your decision as written with the changes that Carter had mentioned?
Oh, good.
Are the board members ready to move forward?
I'm good.
Okay. Does the applicant have any more questions?
I don't believe so. Thank you.
Guess we should have had you go first. I didn't know it'd be so quick. So I'm gonna find my motion sheet. Well, first I'll make a motion to close the public hearing.
So moved.
Second.
All right, Bill Pierce,
Aye.
Carter Brennan,
Aye.
Anthony Zaitin,
Aye.
and I'm an aye. Do I have a motion to grant a waiver of zoning bylaw 7.2 C10 relative to the vision triangles measured in feet from the proposed curb cut along the street on which access is provided?
So moved.
Second.
Okay, Bill Pierce,
Aye.
Carter Brandon,
Aye.
Anthony Zaitin,
Aye.
and I'm an aye. Do I have a motion to grant the waiver of zoning bylaw section 7.2 C12 relative to submission of a comprehensive parking and traffic circulation plan?
So moved.
Second.
Bill Pierce,
Aye.
Carter Brandon,
Aye.
Anthony Zaitin,
Aye.
and I'm an aye. Do I have a motion to grant the waiver of zoning bylaw section 7.2 C18 relative to submission of a lighting plan, as that will happen in the future?
So moved.
Second.
Bill Pierce,
Aye.
Carter Brandon,
Aye.
Anthony Zaitin,
Aye.
and I'm an aye. Do I have a motion to grant a waiver of zoning bylaw section 7.2 C19 relative to submission of a landscaping plan, as that will come further in the future too with the permanent?
So moved.
Second.
Bill Pierce,
Aye.
Carter Brandon,
Aye.
Anthony Zaitin,
Aye.
and I'm an aye. Okay, do I have a motion to grant the site plan application per section 703-050A1C and special permit per groundwater protection overlay district per zoning bylaw section 77010D3B5 to allow the construction of a temporary parking lot consisting of 66 parking spaces, a temporary laydown area, and associated improvements at the property located at 10 Goddard Road, map 17, parcel 11, in the Industrial District and Groundwater Protection Overlay District Area 2, subjects to findings of fact 1 through 16 and conditions A through R. Are those still right, Lori?
Yes.
As amended per the, the wording that was agreed on for Carter and
moved.
Lori.
So
Second.
moved.
All right, Bill Pierce,
Aye.
Carter Brandon,
Aye.
Anthony Zaitin,
Aye.
and I'm an aye. Congratulations.
Thank
Um,
you all.
Members.
Thank you.
Sorry to have put you through the earlier.
Right. I didn't even know this was going to be so quick, or I definitely would have moved you to the front.
That's right. I'm almost an expert in cell towers now. So
I know.
Right?
Thank you.
Okay,
Appreciate
well,
you
thanks a
waiting.
lot.
Yeah,
Have a
thank
good
you so
night.
much.
Thank
You
you all. Have a
too.
good night.
Bye-bye.
Bye. Okay, next on our agenda, which I have to find again. I know it was ANRs. Let me see.
302
So-
and 302 R Church Street.
Yep, 302 and 302 R Church Street. That's an update of an ANR approved on 4/1/25 that was not recorded.
Yep, so this is simple. It's exactly the same A&R. The only difference is they put a revision date of June 29th, 2026. So what happens is the Registry of Deeds gives you 1 year to record an A&R plan. If it doesn't happen within that 1 year, then they refuse to record it. So this was one of those circumstances, so they just need the dates updated so the property owner can record it.
What
Okay.
was it this date they did not submit it to the registry, or?
Yeah, sometimes that happens.
Okay.
Is that, property owners who haven't been through this process before, they pick up the Mylar. Of course, we explain that they have, that they need to go and record it at the Registry of Deeds. And it's not valid until they do that. And then they put it on a shelf somewhere and just forget about it. So every once in a blue moon, this happens. So it's unfortunate that they have to go through this all over again, but it is what it is. I betcha they will absolutely run to the Registry of Deeds with this plan now.
Yep.
I actually had a good number of questions about this one. Because, one thing I saw, because I think what was the date on this would have been shortly before the 2025 town meeting, right? Which was when the lot shape factor requirement was passed. I was trying to roughly do the calculations. I think they all match, but they're not on the ANR. That was one of my questions.
Yeah, I can look. If I remember correctly, I did go through and double check that they were all compliant. I'm pretty sure I have that saved. So just bear with me a minute while I search for that. I do not have that Excel spreadsheet saved, and unfortunately, I didn't bring the entire file with me. I figured you folks approved it before, you'll approve it again. So my bad on that one.
And when is the date when after so many days, it's automatically approved? Do you know when they submitted it?
Yeah, they submitted it on July 16th. So they have, you folks have 21 days to act. which would be before your next meeting. So it's next week is when it expires.
Now, an A&R goes on lot size and frontage anyway, so if it didn't meet the lot shape, would it just have to be right that it doesn't make it a buildable lot?
That's correct.
So I guess I think we can approve it because we have to approve it tonight. Well, I guess we don't, we could deny it, but
It
You might-
wouldn't, it doesn't need to be listed on the thing as long as it's right.
right, so if the lot shape wasn't right, and then they went to apply, would they have to, would Bob reject it if it doesn't meet the lot shape factor?
He should. I could speak to him about that. The lot shape index of regularity is shown on the plan. But yeah, they didn't write it. But I do remember because this was one of the first plan, actually. On lot C, they have it listed 0.41.
Is it? I thought it was lot numbers, not letters. But
it looks like they have it generated for, yeah, they've also got it on lot A. It's the 0.68. They have it on lot B, 1.01. So
they meet it?
they do.
What is? Do you have it? I'm just because it was. At least when I was looking at it, I think it was lot numbers, not letters. So I'm not sure which.
Here, let me bring up the plan 1 sec. Gotta find when I emailed it to you folks. I know it was later in the day today.
I don't think I actually saw an email of it. I saw it on the website.
Yeah, I think you sent us the DPW memo, but you didn't send us the actual.
Okay,
A&R.
hold on. I got so many things open, it's a challenge for me to navigate, so just bear with me a minute. Oh, here it is, I got it. Okay, so let me share my screen. All right. Is this the version we have? Nope. This is the older version of the plan, so just bear with me while I find it. Okay. That is not the version that I have. In my hand here. So let me find the version that I have in my hand. Oh, I see. I was looking at the wrong one. So that was my bad. So I was looking at the Barefoot Road one, which has the regularity factors on it. So, this one I'm gonna blow up a little. Yeah. They do not have it listed. Just the uplands. But as Amy pointed out, the only reason for denial would be lack of adequate frontage, lack of access to the parcel, and lack of the road is inadequate, essentially.
Can you scroll down a little bit? Or yeah, can you just show us like closer to the bottom of the?
Yeah, this one is funky to say the least, as is this one.
Because yeah, I mean, I was trying to kind of calculate what it would be, and I think they all barely meet it. I didn't do lot 6, but I don't know, because isn't there a exception to that? But I also had a few other questions about some of them. If you can scroll down closer to the bottom to I think it's lot 5.
Yeah, Lori, I can share it on my screen if you want.
That's okay, I got it. Lot 5, yeah. In the left-hand corner where my cursor is. What's your question?
No, I can't see.
You can't see it on your shared screen.
Oh, okay, sorry, let me get out and go back in. Can you see it now?
Yes.
The lot 5, it gets really narrow. You have where the frontage is on Church Street, and then the buildable portion of it up there. Doesn't it need to have at least like the 50 feet access to get from the frontage to the buildable portion?
Well, they do have a measurement here. It's 100 feet. And
But
then it
then-
widens from there.
But doesn't it get really narrow? Because it's a line, it's a diagonal line. So that corner is very narrow.
Well, the line goes from here to here. So it doesn't go up and down. It's width, not depth.
But then it still wouldn't, like it, because isn't the,
So
that's
it's
still
it's
an access issue? Like you couldn't really, could you build a driveway? Like, I mean, that's wetlands, but I think that's, you know, the idea is theoretically you could build over the wetlands, but then it becomes very narrow.
So I believe what they're trying to achieve, so what they're showing here is that they want to do a common driveway.
Mhm.
So that is why they have this dotted cul-de-sac,
Yep.
but they have to go to the planning board for a special permit for
Mhm.
the common driveway. So the intent here is that access will be achieved through this
but that's
And then
irrelevant.
the building will be built here.
But for the ANR, it has to have access through its own frontage.
Well, typically the common driveways don't. So the way it works is that they have so they do the common driveway on the most buildable portion of the multiple parcels. So we have many examples of that where the slopes are super steep. So if you think of Reservoir, that was an example. So they could have, but it would have been very expensive and wouldn't be good from an environmental standpoint to build all those driveways through those wetlands and steep slopes.
They could have. I agree with Carter on this,
This is a
actually,
subdivision
like,
then.
yeah, I agree with
It's a
Carter that
subdivision
this,
road, and they're trying to, right? Because if it can't be accessed through its own frontage, then it would not be an ANR lot. I mean, that was at least I was reading through the ANR handbook earlier. That's my understanding.
I agree with Carter on this one. I think he's right.
Well, it's not, I mean, our regulations do allow a certain amount of wetlands to be filled. So usually wetlands are not typically one of those things where you can say it's impossible to gain access over, unless it was like an ocean. Like if it was an actual body of water. But even still, I suppose they could build a bridge.
And again, the ANR handbook, talks about it was challenged in court, and they said the wetlands, no. But again, so it's not the wetlands it's that the narrowing of it there, where I think that doesn't meet. Again, it's supposed to be, I think it's either the frontage or 50 feet. That it has to have, access, for a driveway to go through there. And so that one was, to me, the most obvious one, that it doesn't look like it would have access to the buildable portion from its own frontage.
So does the fact that they have the common driveway on the ANR give them their frontage, right?
Based on what I was reading in the ANR handbook, it's supposed to be irrelevant.
So are you talking you're not talking the frontage on lot 5, you're talking a lot frontage on lot 6.
No, it's
lot 5 has Church Street.
Yeah, lot 5 has the frontage, but the lot becomes so narrow that the access from the frontage to the buildable portion is too narrow.
Because of the wetlands.
Do you know that for a fact? I
can't, there's not a measurement, but I think is it, at least how under our bylaws, it has to be, I think, the frontage. I'm not sure if there's a lower one, but there's not a measurement for us to, I guess, know that.
It's typically 14 feet is the typical width of a driveway. So I suspect that this area is greater than 14 feet. Unfortunately, it doesn't have the measurement on there. But if this is 150 feet, I would imagine that this area right here, from this point to the lot line, is probably in the area of at least 20 feet.
But I think isn't it though still the frontage? Like, it's supposed to be the requirement of the frontage, which I think would be 50 feet.
No, because the lot width is 150 feet. So the width is measured from side to side. So this measurement from the bound up to say the W, that's not your lot width. Your lot width is from this corner right here to this corner right here, and then it proceeds back from there. So it just lightens up from there. So this is your width all the way along. So this is more of like your yard setback. So this is your rear setback.
I'm still kind of doubting the lot's access. And that's not, I mean, there's other issues I have with some of the other ones. Lot 1, I mean, I think it probably you could, but I do know the slope. I mean, like Brewer Street is pretty well raised up from kind of the ground there. I'm not sure where there might be a part where it evens out that you could build a driveway, but I mean, it'd be a very steep driveway for lot 1.
But that's not a consideration for frontage.
But it is for access.
Not really, though. I mean, unless it's a cliff, then just because it's expensive to put a driveway up there, that's not a consideration for ANR endorsement.
They only have access to, right? Lot 1 only has access from Brewer Street.
Yes.
Okay, so that would be a they problem, right? They're not accessing off the common driveway.
No. I mean, again, I have questions about the scenic road as it relates to access, but I think the rest of the board, you know, doesn't share my kind of question there.
For Brewer Street or for Church Street?
Both of them, I believe, are scenic roads. Brewer Street, I mean, like the stone wall, there's like not much of for that one, so that's not really. I mean, it's the slope there that makes me uncertain. I think there might be part of it that's evened out, so that one isn't. It's kind of I have questions about. And yeah, some of I think it's 4 and.
But remember, you're not attesting to the buildability of these lots. All you're doing is creating lot lines.
My question with, again, but it's still access is what I'm questioning. And I think, I mean, lot 5 to me is the one that I really doubt. But the other ones, I mean, I have questions, but I think that, you know, that'd be, again, the scenic road, I think that'd be a court would have to rule on that, and I don't really want to do something like that. But
and the scenic road will come back in front of us, right? Or it won't because it's single family. Well, it's a common driveway.
No, it will. It's a common driveway, so you're going to see it with the common driveway special permit, and then you're also going to see it with the scenic road permit.
So is the only lot 5, is that the only question with the accessibility?
I have more questions, but lot 5 to me is the most obvious one.
Is there any way Carter can type up his question and send it to Attorney Eichmann to double check the accessibility?
We don't have time.
No, remember, it's going to be constructively approved next week.
Oh, I know, but just so we have the answer in the future, and then, well, I mean, we need
Sure,
to get.
although in the ANR handbook, it clearly states that you can't use wetlands as a reason for the presence of wetlands is not justification for denial of ANR endorsement.
It's not the wetlands, it's the narrowness of it.
Right.
Maybe Carter, you could measure it with Lori and see if it has the proper, and then if it doesn't, you know, you could ask Attorney Eichmann, just send a letter with Lori to see if there's a problem with accessibility.
And remember, this is rear setback. This is not lot width.
But there has to be some width to let a driveway go through, because I know what he's talking about is if you build a lot back there, it has to be accessible through the frontage. And if you couldn't get a driveway through there and access the back, then it wouldn't be accessible through the frontage.
Yeah, I mean, if you look at this measurement here,
Mm-hmm.
is 74.37 feet. So it's definitely smaller than that. But it doesn't look to me like it's smaller than 20 feet. And
So a
this
driveway, yeah.
measurement is 55 feet.
Mhm.
So this measure is around 20 feet, and the standard width of a driveway for a single family home is 14 feet.
Okay, so as long as it's 14 feet, they could come up and then take a curve and then go up to the back. Would you be okay with that, Carter, if you guys decide, if you guys can measure and see if it's at least 14 feet?
I mean, I have issues with other ones too but I think I'm going to vote no on it.
Mm-hmm.
I mean, this is a majority vote, so there's 3 yes votes is needed to approve it.
If I do approve, would you sit down with Lori, Carter, and go through all the? Just because I would want to make sure in the future that we're going forward properly.
Yeah, and I mean it's I mean, again, I've been like really attentive to this since the Newton Street one, where it was like it looked like it would have been made sense to do a common driveway, but then it was being the lots are being sold separately, and then you have these lots that like you can't really access, and there was the whole lawsuit issue over that between the neighbors and stuff. And yeah, so that, I mean, I don't expect that to happen with this. I think the common driveway, but I mean, again, it is just, I don't really understand why this isn't just a subdivision. I think that'd be easier. But it looks to me like it would be a subdivision based on, I mean, if it was submitted, it looks like they'd have all the right frontage and stuff. And I'm kind of
How
like,
many lots are on this common driveway?
6.
5. Oh, because I think
5 or
lot 1
6?
is on Brewer Street.
Oh, yeah, I'm sorry.
So if there's over so many, like we can only have so many on a common driveway, isn't it like 3?
The maximum number on a common driveway is 5.
Okay. All right. I'll have to go read that.
And lot 3 already has driveway, so it's already got a home on it. So it would only be 4 that would get their access through the common driveway.
My other question, and I don't think this is relevant for the ANR, but can you have a lot line crossing a building?
The intent is to demolish it.
But I'm just because it's an old barn, so like, do they have to go through historical commission and then get the demolition permit for that? I don't know how old the barn is.
I believe if it's over 75 years, then they would have to do that.
I think it was 150.
And a line definitely can't go through a building because they would definitely lose their occupancy permit.
Yeah, there is a note on there, existing barn to be removed.
Did it say removed, or I thought it said moved?
It actually says moved, but
Oh, okay.
I'm like, is it gonna move?
Yeah, you're right. It does say moved.
Okay. So Carter, do you want to meet with Lori on your other questions? Like, should we go forward? Because I think you already said you're going to deny it.
Yeah, I'm a no vote. Yeah, I have doubts, especially lot 5 and others have actual access that is not illusory.
So if we approved it and it doesn't really have lot access, then what happens? Like,
Then if it's too expensive to build, then it just won't be built on.
well, I mean, it might not be expensive, but it might not have the right access that it needs to actually be a lot.
Well, it does because of, you know, the frontage requirements. So, or if I remember correctly, 2 different zoning districts.
Yes.
Yep. So you have residence B. Minimum frontage is 150 feet. Residence A, the minimum frontage is 200 feet.
That was another question, and again, I think that'd be buildability, not the ANR, but because if the lot is crossing zoning for its which have different lot size requirements, like the dimensional requirements are the one that's more, but I mean, it's in the bylaw, it said like 4 lots that predate the zoning. If this is a new lot, how does that work?
So in our zoning bylaw, it says what happens if a lot line crosses. So let me see if I can find it.
Might still have it on.
Bear with me.
I have it. It's lots. Oh no, that's lots in 2 towns.
Of course, you can never find it when you're looking for it. Does talk about when it splits.
Because it's
2 towns.
I think it was something like for 50 feet the use.
Yeah.
And
Yeah.
but then and then it would be
I
whatever
think
one had
it's
50%.
where the frontage is, you're able to extend 50 feet into the other zone.
But I mean, I just remember there was one part of it where it said for lot, like it was something about lots predating zoning changed. I didn't know if new lots, the dimensional requirements were still the same as it's like the 50. It was, I think it was 50 for whichever one had more.
Yeah, it's. I can't find it quickly. I can find it and email it to you tomorrow.
Okay. All right. And Carter, you can go in and work with Lori if you have additional questions. Oh, she found
I
it.
found it. It's on page 725. Where a lot is situated in more than one district, the use regulations that apply in either district shall apply in both districts for a distance of 50 feet on either side of the district boundary, provided that the lot existed at the time the district boundary was drawn and dimensional regulations of the district in which more than 50% of the lot is located shall apply throughout.
So I guess that was why I was confused, because oh, is Lori frozen or am I frozen?
Yeah, you're both back.
Okay. Yeah, that was why I was kind of confused. Because of that phrase that provided the lot existed before the zoning
Well,
line.
these are the creation of new lots. So the grandfathering doesn't apply.
So that's like my question is about again lot 5. Because it crosses a little bit into RA. Would the dimensional requirements be for RB, because it's mostly an RB?
It's yes. More than 50% of the lot is in RB.
Mm-hmm. Even though it's a
So you
new
treat
lot?
it as if the entirety is in RB.
Mm-hmm. Just even though it is a new lot?
Yes, because it says where a lot is situated in more than one district.
Okay. I mean, it doesn't matter for this purpose, but yeah.
Okay. So, I mean, there are two things we can do. We can vote on it, or we can let it just, we've done that before. There's one ANR we had a ton of questions on. So we just kind of didn't vote and it constructively approved, but that gives Carter the time to ask questions too. I don't know what board members think about that. Do you want to vote on it or do you want to just let it go?
Well, either way, let's kind of move along. It's getting late. I'll vote yes on this, or if you want to let it lapse and let it automatically approve, that's fine too.
Yeah, I mean, I'm
Does it
gonna be a
matter,
yes
Lord?
on this as well. So we got a
You know,
majority.
it does sometimes cause questions if if there's a constructive approval, but it's up
I
to
mean,
you. You
I'd
folks
rather
approved it
vote no,
previously.
but
No, Carter's voting no. So, I mean, and I understand a lot of Carter's questions, so I would rather I want to see his questions
I
answered.
mean,
And
could we
if,
vote? I mean, I don't know if, even though it's not relevant to the ANR, could you vote to deny it with without prejudice because it doesn't have the lot shape factor on it?
If you deny it, then it'll be appealed and then it goes to court.
I
and
mean,
it
would
just
it
costs,
necessarily be appealed, or wouldn't it just be easier to come back at the next meeting?
We can't come back to the next meeting. It has to be approved by this weekend.
But if it
They
was
could,
denied, wouldn't it be easier for the applicant to just come back than to appeal it?
Well, they have to appeal the decision first, so that's a court case.
Okay.
but if they changed it, they wouldn't have to appeal it, right? If they made a change.
What would they change though?
Add the, I mean, I'm saying, I mean, even though I'd still be a no, but
But it is
if it-
kind of irrelevant because it only has
Mhm.
to do with the buildability. So the building inspector is going to apply I mean, first of all, we don't know that they don't meet. So
Mhm.
you're just assuming that they don't.
well, I mean, could you say just get like it needs that measurement there?
Yeah, you would need an actual measurement. And the building inspector is going to go over with his tape measure and like he says, put the dumb end on one end and put the smart end on the other and see if it measures 14 feet. So, he's going to do that either way.
Well, if he'd really look at accessibility.
It's not going to be built that way anyways. But it's just, it's the question, really the question of it is whether they have to go through the subdivision process, or if they can do them as ANRs and just do the common driveway, which
well, we could probably deny the common driveway if it's supposed to be a subdivision when it comes in front of us. Would that be possible, Lori?
No, so then what they'll do is they'll just build separate driveways for all of the lots. So then they'll just go to the Conservation Commission and ask if they can fill the wetland.
I do think there's probably the 14 feet there to get the driveway. I do think that's a good catch though, because I do think it's a weird shape. And you are supposed to have access to the lot from your frontage. But I am gonna move it forward and we'll take a vote, but I hope Carter, you work on it with Lori and get to the bottom of this. And next time if it's before the meeting, and I don't know, you maybe didn't have time before the meeting, but you could go to Lori and and see.
Didn't we discuss on Newton Street, we had John Eichman there? And I'm pretty sure we discussed about the whole scenic road thing and how you can't use the fact that there's a scenic road as justification for denial of an A&R. I'm pretty sure we got an opinion on that.
But I was talking about the accessibility of that shape of lot 5. I wasn't talking about the scenic road. But I do think you can't deny an A&R because of the scenic road. I do think someone said that. All right. I am gonna take a vote. If everybody's okay with that.
Yep.
And then you can work it out, Carter, with Lori and get to the bottom and see.
Okay.
Do I have a motion to endorse the plan titled Approval Not Required Plan 302 Church Street, Northborough, Mass. 01532, dated March 13th, 2025, revised June 29th, 2026, prepared by WDA Design Group?
So moved.
Second.
Do I have a second? All right. Bill Pierce,
Aye.
Anthony Zaitin,
Aye.
Carter Brannon,
no.
and I'm an aye. So, but I do want to find out. And then there's the A&R for 10 Bearfoot Road, 30 Bearfoot Road, and 230 Salmon Pond Road. Can you describe that, Lori?
Sure. So we did get a letter from Quentin, as well as from his attorney, explaining what the issues were with this one. They was one that you folks approved a couple of months ago, and the Registry of Deeds would not record it because the information wasn't adequate on the plan. So they updated the plan to include the missing information. There were no lines, no changes whatsoever to the lot lines and the meets and bounds. So they're just asking you to approve it with the changes to the descriptions. And that's it.
Okay. Does anyone have any questions?
No.
No.
Okay, do I have a motion to endorse the plan entitled A&R 30 Barefoot Road, 10 Bear Limited Partnership, 10 and 30 Barefoot Road, Northborough, Mass, dated July 9th, 2026, and prepared by Kelly Engineering Group?
So moved.
Second.
Bill Pierce,
Aye.
Anthony Zaitin,
Aye.
Carter Brennan,
Aye.
and I'm an aye. Okay, I'm assuming we have minutes on the agenda next, but Carter, you gave Lori some changes. I didn't have time to read them, so
Most of them were small. I mean, if
they're
you want to,
small. If they're really small, you can pull it up. I usually agree with everything Carter says, so if you on
I
the
remember.
minutes, I mean, it would be good to get them in.
There was extensive changes to the July minutes. So I didn't send those out, but I did send them out. Let's
I think-
see.
I think I think it was the May. I think the only change I made was noting when I rejoined the meeting.
Oh, okay. Then I'm fine with that.
And then I think the July ones were I changed some typos like Board of Selectmen to Select Board. I added where I think I had asked a question and a resident kind of said, "Oh, thank you for asking that. That was my concern." And then there's a couple other things where it was like, I think I changed Edmund Hill to Edmund Hills to Edmund Hill, and like clarified that I was talking about 2 properties instead of 1.
Okay, I'm fine with that. Do I have a motion to approve the May 19th minutes as amended?
So moved.
Second.
Okay, Bill Pierce,
Aye.
Anthony Zaitin,
Aye.
Carter Brandon,
Aye.
and I'm an aye. And the other ones were what, July 14th, was that it?
And June 9th.
I don't think we did June 9th. I didn't do June 9th yet. I didn't have time.
Okay.
And there
But
was
then-
one meeting I wasn't at. Which one was that?
I don't know. But which one did you make changes to? July 14th?
These are the June 9th.
Oh, okay. I didn't do June 9th yet, so I'd like to skip
Okay.
those if we can.
Okay.
I'll try to get those for next one. I don't think I sent changes. No, I only did 2, May 19th and July 14th.
I also have the July 14th.
Did you have changes to those,
Um,
Carter?
I
Or you haven't
think
read them yet?
so. Yes, that was my
Okay.
one of my changes, and then I think there was a couple other places, but they were mostly just typo kind of things. Yeah,
Oh, yeah.
select board. And then
All right, those look good. Do I have a motion to approve the July 14th minutes as amended?
So moved.
second.
Okay, Bill Pierce,
Aye.
Anthony Zaitin,
Same.
Carter Brennan,
Aye.
and I'm an aye. So the minutes for May 19th and June 14th July 14th have been approved. And I think that's all on the agenda tonight. I don't think we need to go through old business, new business right now. Unless anybody wants to, seeing it's 10:30.
Nope. So next meeting is August 10th and then August 11th.
Yep, August 10th and August 11th.
August 10th, just the
Yep, just the cell tower. I don't want to add anything else because I am on vacation that week.
okay.
My daughter's only in once a year, and this is the 1 week I'm gonna miss.
And should
2
it just
nights
be
of
the
it.
vote or
Is it too late to consolidate everything to Monday?
What was your question, Anthony?
Is it too late to consolidate Tuesday into Monday?
It is because
Okay.
you guys continued the public hearing to the 11th
So we
for
can-
the 17 Green Street.
And if they're not ready, they were gonna bump to September 1st.
I
Have they
can
gotten back
check
to
with
you?
them.
Maybe they're not ready.
Then you'll still have to meet quickly to continue the public hearing.
That's,
Yeah.
that'd
But
be
Amy,
okay.
I can always do that.
Yep. So we'll cross our
Guys,
fingers.
I still haven't seen any revised plans for them as of yet.
Okay, and when do they have to get them to you? Oh, you're leaving.
Yeah, I was hoping that they were gonna send him over last week. That's what they had said.
Well, okay, well, maybe we'll get bumped to September 1st. Okay. But you'll find out for us by the end of this week. If you don't have them by like Wednesday or Thursday, you're not going to be able to read them.
Correct.
Okay, so just let us know.
I will.
Do I have a motion to adjourn?
So moved.
Second.
Phil Pierce,
Aye.
Anthony Zaitin,
Aye.
Carter Brennan,
Aye.
and I'm an aye. I guess we lost Millie. I didn't even notice for a
Yeah,
while.
we left her after the cell phone, after the cell tower.
I gotta try that move. Just take off.
So what happens when you're not on camera.
All right. We'll see you guys on the 10th.